All right, I'm going to go ahead and call the meeting to order, since I know we have a lot of business this evening. Good evening, ladies and gentlemen, attendees and participants, and welcome to the September 14th, 2021 meeting of the City of Tampa Variance Review Board. From my left, the members of the board are
Aaron Murphy.
Una Johnson.
Brett Feldman,
Dustin Pastor.
Lynn Hertak. Sam Decker.
David Farrell.
also in attendance this evening from legal, we have Kamaria Pettismackle, and guest star, we have Simone Savino. From development coordination, we have Anastasia Barnes, and guest starring Jane Madu. From natural resources, we have Stephen Eister, and from transportation, we have Jonathan Scott. There are some procedural rules we need you to follow this evening. Due to the COVID-19 pandemic, please adhere to safe social distancing as set within the room. Please maintain wearing facial masks at all times. When your case number and petitioner's name are called, please approach the podium. When you approach the podium, please state your name, your address, and if you have been sworn. The petitioner and or their agent will have 10 minutes to make a presentation. All other persons or participants wishing to speak will have 3 minutes, and then the petitioner will have an additional 3 minutes for rebuttal if needed. The time periods as stated will be kept by the board. Any additional information, such as pictures or plans, that have not previously been submitted as part of your petition and you intend to present at this hearing for consideration in support of your petition must be individually presented and accepted by the board. After acceptance by the board, you must submit the item to staff and it will be entered and made part of the permanent record. The board in its decision bases its decision on competent and substantial evidence which is presented and which meets the criteria required by the city's code of ordinances. Please be sure to clearly state your hardship criteria during your presentation. A majority of the board is needed to approve your variance. A variance granted by the board will be only for what is shown on the site plan and will be in compliance with the terms and conditions stated in the approval by the board. All other city codes will need to be met. If the case is approved, your variance will expire 2 years from the date of decision. If the case is continued, it will be continued to either the next month's VRB board agenda or the next available position on an upcoming VRB board agenda. If the case is denied, you may wish to have the Variance Review Board's decision reviewed by the City Council. You must file a petition for review of the board's decision within 10 business days of the written decision. You will not be able to pull any permits until after the 10 days review period has passed. Your cooperation in ensuring that this meeting is run smoothly is greatly appreciated. Can I please have a motion from one of the board members to approve last month's meeting minutes?
So moved.
Second? Thank you. Let's go ahead and have a vote. All in favor of approval, say aye.
Aye.
Aye. All right. The minutes have been approved. Ex parte communications, I'll direct it to legal to determine if there are any ex parte communications or conflicts.
Good evening, board members. Kamaria Pettismackle from the City Attorney's Office. Will the board members please state whether or not they have had any ex parte communications regarding any of the items on the agenda? Hearing none for the record. Additionally, will the board members please state whether or not they have any conflicts of interest regarding any of the items that are on the agenda?
Yes, I've got a personal relationship with the craft, VRB 20-06, and the Goddard position, which is VRB 21-94.
And, sir, or do you mean the first case is 2060, right? You said
2060.
Okay, I think you
Correct.
said 06, but
Sorry,
2060?
2060.
And were you able to, and you said you have personal relationships with both and you know information regarding the applications?
That's correct.
Okay. Were you able to fill out the form related to your disclosure?
I was.
Okay, thank you so much, and I'll make sure Madam Clerk has that.
Thank you.
Thank you, Mr. Chair. And now we just need the swear-in.
Well, okay, do you want to do changes to the agenda after
Oh,
the
yeah,
swear-in?
that's right. We
After
could
the
do
swear-in?
No,
You
we
wanna
could
it
do the
first?
changes to the agenda.
Okay, let's go ahead and do the changes. If there are any changes to the agenda, let's do that now. Ms. Barnes.
Anastasia Barnes, I did receive an email from the agent for VRB 2124 to request to move that item to the end of the agenda.
Okay, and we need to vote on that, is that correct?
Yes.
Okay, do I have a motion from one of the board members to move VRB 2124 to the end of the agenda this evening? Anyone?
I'll have a motion that the BRB 2124 may be moved to the end of the agenda tonight.
Thank you. Thank you, Ms. Johnson. Is there a second?
Second.
All right. All those in favor of moving VRB 2124 to the end of the agenda, please say aye.
Aye.
Any opposed? All right. VRB 2124 is to the end. Any other changes to the agenda? You can just shake your head. Okay. Let's go ahead and do the swearing in then, please.
Everyone please rise. And please raise your right hand. Do you solemnly swear or affirm that the testimony that you're about to give today is the truth and nothing but the truth? Thank you. You may have a seat.
All right. Time for the first case, VRB 20-60.
Oh, and I'm sorry, I see, okay, thank you. He's, just for the record, Mr. Murphy has recused himself from consideration for this application.
Good evening, Anastasia Barnes, Development Coordination. The first case before you tonight is VRB 2060. The property owner and applicant are Chris and Rebecca Kraft, and the agent is Stephen Michelini. The property address is 1508 South Erewhon Avenue, and the zoning is RS50. The request is to reduce the rear yard setback from 5 feet to 3 feet to construct an in-ground pool in accordance. PC. Oh.
Do the board member,
You don't see
Not
it?
here. Up there we do.
It's on PC.
Oh,
If
so
it's on DOT-CAM,
apologize.
they will be able to see.
Okay.
But you
Have to see it. I have to see it.
You see
Got it.
now?
Got it.
Thank you.
So the property address is 1508 South Erewhon Avenue. The request is to reduce the rear yard setback from 5 feet to 3 feet to construct an in-ground pool in accordance with section 27290.31A. This case was first heard on November 10th of 2020 and was continued to February 9th, 2021, and was approved with a 4-2 vote. The application was appealed to City Council. The petitioner, Carrie and Barbara O'Toole, and agent John Grandoff. The City Council heard the application on June 17th, 2021. Subsequently, City Council remanded the case back to the VRB. Just a little background information again. Here's the aerial of the subject property and surrounding zoning, as well as the site plan that was originally submitted, showing the proposed pool, as well as pictures of the backyard of the proposed pool and adjacent neighboring property. In accordance with Section 2780, the board will grant a variance based on the criteria responses provided. And staff is available for any questions you might have.
I have a question.
Yes.
So, since we've already heard this and it's been remanded, do we have to hear the whole case, or are we just hearing new information?
Yes, Mr. Pastor, Kamaria Pettis-Mackel from the City Attorney's Office. There is one new board member who wasn't present at that time. So I'd ask us, for due process reasons, that the that the applicant or the property owner presents the case.
Okay.
Mr. McElhaney, you know the drill, name, address, sworn.
The Crafts at 1508 Arowana. First, let me state for the record that there was no case presented at the city council.
Have you been sworn?
Yes, sir, I've been sworn. There was no case presented at the city council. The opponent asked for the remand based upon procedural questions, and so they never heard the case. But they did agree to remand it back to the VRB for additional testimony and for clarification on our request. So let me first state that this petition was originally heard, as the staff said, last year. And let's talk about the hardship and the practical difficulties first of all. The VRB is authorized to grant this based upon us demonstrating that there is a hardship or a practical difficulty. And what we talked about and what we're presenting tonight is that it's a relatively small lot. It's fully developed. It's a 50-foot lot in width and 100 feet, basically 100 feet in depth. We have 20 feet in the remainder portion of the property from the rear property line to the existing structure. We're proposing a 10-foot wide pool for therapy for a handicapped person, which is a family member of the petitioners. It is unique with respect to the fact that it is a relatively small area. This is a moderate-sized pool. We also have the documentation, which the engineer will go into shortly, that talks about the minimum width that's necessary for a hydrotherapy pool, the access for handicapped persons, and also what is required in terms of drainage and retention that might potentially affect off-site properties. We've done a thorough analysis of that. We've gone back through and we've actually had our civil engineer go through and do a drainage study with not only this parcel but the surrounding parcels to determine the source of flooding, if any. And in the construction of this pool, the property owners will be, through their design, conveying the water from the rear through drains to the front of the property, which is typically required by code. They're also removing 300 square feet of impervious surface and replacing it with semi-pervious surface, which is a type of granite, type of concrete that actually allows for the improved surface for drainage purposes. There are practical difficulties associated with this because of the location of the home and the access for a handicapped person coming out of the rear door and accessing the pool deck and then being able to traverse that deck to a handicap accessible lift. It does not substantially interfere with the rights of others. It never has been. It's contained wholly on their site, and it does not create any off-site conditions that would warrant this to cause a problem. It is in harmony with the general intent and the context of the code and the comprehensive plan. We are in some very strange times now where we are sort of bouncing in and out of health concerns and safety concerns as well as care for children, which is also part of this issue regarding the crafts. Allowing this variance substantial justice would be done. We have been in this process for an extended period of time, and we have supporting letters from all of the surrounding property owners except for the opponent, and I'm sure they will point that out. We went back and had additional letters signed, which I'll be happy to put into the record, just to confirm that these individuals were continuing to support this petition, and I'd like to send those into the record. Yes. We also were questioned about the structural necessity, or at least the distance requirement from the existing house, because I had put on the record that the structure itself had to be a minimum of 6 feet and preferably 7 feet away from the existing structure. I have a record, a letter from Joe Belt from Belt Engineering indicating, and I'll read this into the record, Belt Engineering has examined the associated documents and information regarding this issue, and below is our opinion, and we provided them with site plans according to what we had submitted to the city. The below is our opinion based upon our review and past experience. It's long been a rule of thumb to set the pool edge away from the foundation edge by a minimum distance equal to the excavation depth plus 1 foot. The excavation depth of the pool is proposed at 5 feet. So that makes it the minimum of 6 feet. In this case, the excavation is approximately 6 feet, so a 7-foot separation is appropriate. Similar language has been used in previous residential code editions. Should you have any questions, you may contact Belt Engineering, and I'll submit this into the code, into the record. In addition to that, we have the doctor's prescription that I'll also provide you with copies. Where it says the 88-year-old patient is in our office, Mrs. DeCola would benefit greatly from home therapy and hydrotherapy to maintain her mobility and strength. The process that we've gone through has been long and arduous, and we would respectfully request that you consider that the Crafts have genuinely tried to do their best to make sure that no one was adversely affected and that in fact a 3-foot setback from the rear property line was warranted. A couple of other notes, and then again our engineer will go into this in detail. There are prohibitions against affecting any off-site property from the city code. Notwithstanding, and I'm reading from the code, notwithstanding the issuance of a permit by the city, the compliance with the requirements of Chapter 21 of stockpiling material, grading, excavating, or other acts affecting drainage shall not change the surface drainage patterns to the detriment of a neighboring property. In this case, we're providing drains which will take the water away from the rear property line and take it to the front of the property. And this was out to the street away from the rear property. I also had presented to you, and I'll show it to you again, and what the engineer can go through this, the accessibility equipment requirements and the design for that. In deference to what we have tried to do and in terms of drainage calculations, I'm going to show you a diagram which shows that we have currently, with the pool, we'll have 50% lot coverage, which is the minimum standard for the code. It's actually 50.6%. So we're slightly over, but with the removal of the existing impervious deck, it will be at or below the 50%. And the green area will show you exactly what that area looks like. This is a site plan showing the 10-foot wide pool, the 3 feet off of the rear property line and 7 feet off of the house. And then the drainage plan, Mr. Hinder will go through and explain to you exactly how that works. The bottom line is we cannot affect off-site properties in any manner adversely. And the code says that these are typically handled at permitting. It's not normally an issue that the Variance Review Board handles, but it is something that is a standard at the permitting process. We've spent a great deal of time trying to make sure that we've addressed all of the concerns regarding this. We believe that we have met the criteria with respect to the hardship and practical difficulties. I'll be happy to answer any questions you have, but I'll reserve the rest of my time. Actually, Mr. Hinder is going to come up and go through the engineering report with you.
My name is Eric Hendra, up with Hendra and Associates at 5028 West Longfellow Avenue, Tampa. I have been sworn in. I've been asked to come join the Crafts to examine the complaint of a drainage problem through the rear yacht lot that was collecting a lot of water. I did a pretty good investigation through pictures and looking at the grades, looking at evidence of ponding, looking at drains off the roof as best I could through aerial photography and everything else. I have put that in the report of my findings about what general area has been collecting for the contributing area. The Crafts property does slope from the back of the house toward the common property line within the back. Same with the Georgia property that comes towards. There's a lot of roof drains that go down, but there's no conveyance to get out of those lots to the street, which is one of the rules under the Drainage Board, city's technical standards to get it out to the right-of-way as best we can. The proposed plan that's coming up with the pool and everything else, and when I examined the design there was components there that would at least direct the water back out to the front, away from there. And as that case comes in, that contributing area that was previously done in existing conditions will no longer do that in the proposed conditions.
We're running up against the end of your time. I'll give you a little bit of leeway, but I'd ask that you wrap it up, please.
Okay. I guess to summarize it, basically, mostly all this proposed work has designs and elements in there to direct it away from the backyard to alleviate the problem and hopefully resolve some of the issues. But some of the remaining issues that are found on the site have to be contributing from the other properties that they have no control of. So I believe I'll leave that for any questions.
Okay, if that concludes the presentation, we'll go ahead and open it up to public comment. Thank you.
Is that better? Okay. Good evening, Mr. Chairman and members of the Variance Review Board. My name is John Grandoff. My address is Suite 3700 Bank of America Plaza. I'm a member of the Florida Bar, and I represent the Toole family, Carrie and Barbara Toole. Before I begin...
You've been sworn.
Yes, I have. Yes.
Thank you.
Before I begin my argument against the variance, I'd like to inquire of Mr. Hendra, the engineer. I have probably 2 minutes of questions I'd like to ask him if he would come forward. If he'd stand here, and I'll stand here, and I'll direct the questions to him.
That's fine. Ms. Pettis-Mackle, do we need any motion to adjust our procedures to allow this, or is this okay without such a motion?
This is Kamaria Pettis-Mackle from the City Attorney's Office. This process is fine. I don't know if Mr. Grandoff, this is going to be a part of your time, or you'll just see.
We will allow a little, we gave petitioner a little bit of
Okay,
additional time. We'll certainly give him additional flexibility as well in that. But yeah, to answer that question, do you intend to utilize this as part of your time?
No, Mr. Chairman, I'd like, this is additional evidence in addition to the hearing that we had previously had. I'd like this not to count. This will be maybe 2 or 3 minutes. I'm only going to inquire as to his testimony, not as to his reports. So
Okay.
I'll save some time.
All right, why don't you go ahead and start your presentation, and we'll deal with the time when it comes up, okay?
Good evening, Mr. Hendra.
Good evening.
Are you a licensed civil engineer in Florida?
I am.
And you own your company, Hendra and Associates?
I have.
And you prepared the report that's before you right now?
Yes.
You mentioned a little while ago that a drainage problem exists right now. Is that correct?
That was brought to my attention, yes.
Is that yes or no?
Yes.
Okay. And the stormwater is reaching the Toole's property, correct?
Yes.
Okay. Have you reviewed a survey of the Tools property?
I reviewed the survey and your engineer's report.
Would you agree that there's a change in that elevation between the Tools property and the Crafts property?
Yes,
And the Tools property is lower than the Crafts property?
yes.
Okay. You said you've prepared some plans to alleviate the problem.
I have not. I didn't prepare any plans.
You've recommended the preparation of plans
Correct.
to alleviate the problem, correct? Have those plans been prepared yet?
They've been submitted to the record.
Okay.
You already reviewed those.
Okay, thank you. And that's the report you have before you. Okay. Have you been on the Tools property before?
I have not.
How do you know that there's a drainage problem on the Tools property?
Evidence of rack lines where the water has been standing, where the grass collects on the walls
Okay.
and overlook the walls.
And that's your professional opinion?
Yes.
That's all I have. Thank you. I have one moment, Mr. Chairman. Thank you for that indulgence. Members of the of the Variance Review Board, the Crafts can build a pool today. It just has to be 5 feet from the Tools property. Their own expert has already testified to you that there is a drainage problem. They have not satisfied criteria number 3 of the zoning code, which says the variance, if granted. Okay, now we're going to go from 5 feet to 3 feet. If granted, will not substantially interfere with or injure the health, safety, or welfare of others whose property would be affected by the allowance of the variance. They have a problem with no pool. They're going to put in a pool. The water is impervious, and they're going to build it 3 feet away from my client's property. Their own engineer admitted there's a problem right now. I put into evidence at the previous hearing there's about a 6-inch difference in elevation at the back of the Craft property and the back of the Tool property. This is absurd. You don't need to have an engineering seminar to know that the explanation that Mr. Michelini gave to you has nothing to do with the condition of the property. Ironically, the condition of the property is it's a drainage problem. And they're going to put more water on my client when they build the pool. Now, excuse me. Now, the code says, criteria 1, the alleged hardships or practical difficulties are unique and singular with respect to the property. Not, I need a pool because I want a pool and I want it to be 3 feet from my client. Or with respect to the structure or building thereon. They bought a 50 by 100 foot lot with a house on it. They were on notice when they got the survey to walk on the property and notice if we're going to build a pool, it's got to be 5 feet. We can't come in later and say, well, you know, this is unique. A 50 by 100 foot property is not unique in this neighborhood. It's a bigger house. That's the way it goes. That is a personal issue. It's not my client's problem, nor should my clients bear the burden of the water. All this rubbish about I'm going to take care of the water, we're going to meet chapter 21, we're not going to put water on the property, has nothing to do with the criteria. They have to meet the burden first of proving that it is a situation with the property. A triangular lot, a tree is in the way, a water body is in the way. That proves a hardship unique to the property. Mr. Michelini tells you, pardon me for a moment, it's a small lot. This is for a family member. It's a small area. It's a pool for therapy. He admits there's a big issue of drainage.
Mr. Grandoff, your time is up, but I'm going to allow you a little bit of additional time, similar leeway to what I provided earlier.
I'll
Just
wrap up,
please
right?
wrap it up as
I'll
soon
wrap
as you
up
can.
right now. He's asking for the minimum width. Access for a handicapped person. We're sympathetic to that situation. but there's a drainage problem. They're going to exacerbate the problem. My client does not need to take the risk that they'll solve the drainage problem if they haven't proven a unique situation to the land. And that's it. The inquiry's over. You deny the variance. We did not create the off-site conditions. We are sympathetic to their issue, but that is not what the law provides. I respectfully request that you deny the variance this evening. Thank you.
Are there any other, before Mr. McElhaney comes back up, are there any other members of the public who would like to speak on this petition? Seeing none, I will open it up for board questions. Does the board have any questions? Mr. Farrell.
If I'm not mistaken, when this was here last time, this is questions for Mr. McElhaney. Wasn't the issue that by the time you opened the French doors and got the infirmed in-law into the apparatus that it needed to fit, that infirmed individual needed to fit into, that was in essence one of the reasons that that pool was being moved, so that the physical element of being put into something that could get them into the pool correctly was a mitigating factor?
Yes, sir. The exiting from the house to the deck had to be a minimum width, and we were providing that safety area for that to occur.
And one quick question, and I'm sorry, I don't know, again, it was a long time ago. Do the tools not does the property owner to the rear not have an accessory structure there?
They have a couple of accessory structures. I can get into that in my rebuttal.
Isn't one of the accessory structures sitting actually on the property line? At one point, I remember a picture of an air conditioning unit, a window unit that had been cut into a fence that these owners had that was draining into your client's yard. I didn't
Yes,
see
sir.
that on the survey, but is there not a contributing structure that sits actually on the property line virtually?
Yes, sir.
So there is no, in other words, there's no relief for your client from space from the accessory structure. There are windows that line that accessory structure that allow the tools to freely look into the backyard of your client, correct?
Kamaria Pettis-Mackle from the City
Yes, sir.
Attorney's Office. So, and I apologize for stepping in.
I have a diagram.
I just want the board members to focus on what the request is for this application. It's the request regarding the reduction of the setbacks for purposes of the pool. But I just wanted to remind the
Yes,
board.
ma'am, and I
Okay.
appreciate that, but I remember specifically that there was an issue with a mechanical issue, that by the time a 3-foot French door opened and you had a physical machine there, that there was some
But that's-
issue with getting it around.
Hold on a second.
That was part of the testimony months ago, I don't
Point of
understand.
order. He's testifying.
Kamaria Pettis-Mackle for the record. If you have a question for
Yes, ma'am.
the applicant, it's appropriate to ask a question, okay? Now, again, I just want to remind the board members, this is before you regarding a reduction of the setback regarding a pool. This is not an issue about an accessory structure from the neighboring property, but whether or not the applicant has met the hardship criteria regarding the reduction of the setback. And again, if you have questions, please.
I'm sorry, I just wanted to remember, that I was just remembering the
Yeah, but-
details
yeah,
of
just
the
ask the
case
question.
first. Yes,
Okay.
ma'am.
I have a question. Ms. Pettis, are we able to consider the previous testimony we heard, or are we supposed to rely solely on what we've heard tonight?
So, Kamaria Pettis-Mackle for the record, the applicant and the public, members of the public have presented this before you this evening. I hear what you're saying about what was presented previously, but as I stated before, there's a new member here who was not a part of that process, and that's why this case is being re-presented today. So I'd ask the board members to consider what was presented today, since this is presented to the board.
Right, so since this is not a continuance, Mr.
This-
Farrell, what we heard before is not relevant. That's my point.
Wow. Okay.
Indeed.
Is that correct, that they can't consider the previous testimony? The remand was for, I thought, additional information and clarification. Why would they ignore what was previously testified?
Mr. Michelini, I cannot, this is you have to prove the burden.
That's fine.
Okay.
So is it more questions or?
Yeah, I have another question, and this one's for Mr. Grandoff, if you don't mind. Mr. Grandoff, would you mind?
You still have a rebuttal at the end.
I got it.
You have a question, okay.
Do you have an additional question for Mr. Michelini while he's standing here?
Okay. Why don't you go ahead first, Sam?
Mr. Randolph.
Yes, ma'am.
So, you talked a lot about the drainage issue. Is your client opposed to the pool, or are they opposed to the impact that the pool will have on their property?
The second,
Okay.
here's the situation. They're not opposed to the pool. Please build the pool, but build it 5 feet away. There's a proven drainage issue. By their own admission, this will exacerbate it.
And that touches almost exactly upon the issue that I was going to ask you about. Help me understand,
Yes,
if
please.
you would, please. The applicant says that they intend to put additional drainage onto the property. They say that they intend to help try and alleviate the water on the property. Help me understand how a pool being installed 5 feet from the property line versus 3 feet from the property line, how that is directly going to impact the drainage issues, considering that the city says we have to deal with water when we build things, right? We have to take it out to the front. Help me understand that, please.
To build a sufficient drainage, you need the 5 feet. My opinion is that the 5 feet is set in code to provide room to put a swale, so the swale doesn't have to straddle the property line. So you have 5 feet of swale instead of 2.5 feet of swale, or 1.5 feet of swale now. So I think that's why you have a 5-foot setback for a pool, because there's no slope in Tampa.
I appreciate that. The point you just made, though, has me concerned. You said, my opinion is.
Right.
Are you presenting evidence of that?
No. I'm answering the question of why 5 feet. I think 5 feet is better than just 3 feet,
Okay,
personally speaking.
all right. Well, then, let
Please
me,
build it at 5 feet.
if you have more to say on that, tell me, for sure.
Well, the issue of the window and the door not opening, that's all personal issues. You're not here to solve a personal issue with the property.
That is a separate issue, you're right, but that is not addressing the question that I asked,
I'll
which
go
is
back
about
to-
the drainage.
I'll go back to the drainage, Mr.
Okay.
Feldman. In my opinion, you never reach the drainage question, okay? Because the drainage question is in criteria number 3. You have to address criteria number 1 and number 2 before you get to 3. If you don't clear 1, it's over. You have to meet all 5.
Okay.
We're getting hung up on criteria 3. We're forgetting about 1 and 2.
And that's a fair point. We'll get back to criteria number 1 in a second. Let me ask Mr. Michelini the issue about drainage, just for safety's sake, so that we cover that issue, and we can get back to criteria number 1. Mr. Michelini, can you touch upon the issue? Have you presented any evidence to us this evening to address how the drainage would be mitigated if you're going 3 feet versus 5 feet?
Yes, sir. It's in the report that we provided to you
Okay.
and the supplemental addendum.
This report that,
You have 2 reports. You have
Okay.
the original report and the addendum. And I'd like to ask Mr. Hinder to come up and let me ask him a question in the same manner that Mr. Grandoff asked him. I just want to clarify the drainage issue, that's all. And then I'll go
well,
on to...
why don't I ask Mr. Henrik the question
You
about
could
the
do that.
drainage issue?
I would appreciate that.
Okay, that may be the area.
He's the licensed engineer. It's not a matter of an
Would
opinion.
have been just as appropriate for you to say Mr. Hendrick can better answer that question,
Yeah.
Mr. Michelini. Sir,
Hi,
Hi.
Eric Kendra here.
can you explain to me the difference and how the drainage if at all, is being addressed in a pool that is installed 3 feet from the property line versus 5 feet from the property line?
If it's 5 feet, we can put a swale at a gentler slope between the property line and the pool deck to collect and drain to the front. If it's 3 feet, it'll be a little tighter, and the slopes will be a little tighter. We can also put in an under drain or a pipe of sufficient size, usually a 6-inch will handle that little area, that drainage area, to get it to the front. So 6-inch pipe with 3 foot, you still got 1 foot on either side between the property line and the pool.
And is it the petitioner's intent to put a pipe in there to drain out to the front of the property?
I am not aware of that at this moment, but we will address that during permitting issues and
Okay.
drainage.
Mr. Michelini, can you
We
answer that
committed
question?
to it, yes, I was informed.
The Crafts committed to that.
Okay, all right. That, I think, that addresses, at least in my opinion, that addresses the drainage issue. Ms. Pettis-Mackle, we talked the last time, and I want to make sure the record is clear this time and that I am not misremembering anything. ADA issues, any consideration for those? You're shaking your head.
Kamaria Pettis-Mackle, for the record, no, they have to be able to determine the hardship criteria. There are no ADA issues that can be considered regarding this. They have to show that they meet the hardship criteria.
Okay, great. Mr. Michelini, you talked earlier, almost at the beginning of your presentation, about the hardship issues. Will you reemphasize those for us so that I am clear upon those?
Yes, sir. We provided you with an engineer's report from a structural engineer who said that a 6-foot separation from the main structure was the minimum. We requested 7 feet because of the additional maneuvering area that was required for the handicap. Can I divert for a second, or am I in rebuttal, or am I just asking you?
No, that you will have your time in rebuttal later.
Okay, that's
So
fine.
it would be
So-
most helpful if you could address the question.
Yes, sir. We went through the hardship criteria. Basically, there's 20 feet on the rear of the property for an existing property that's fully developed. And we have proposed a 10-foot wide pool with a 7-foot separation from the house and 3-foot setback from the rear property line. We had exacerbating conditions that are off-site that are not related to us that involve the drainage. And some of the issues were self-created by the opponent.
Not concerned about drainage.
Okay, that's fine. So anyway, we gave you an engineer's report that told you 7 feet was sufficient, 6 feet was the minimum.
Okay. Mr. Grandoff. Sorry to make you keep jumping up. I pushed you off when you were talking about the first criteria. Want to give you an opportunity to talk about that. Mr. Michelini just explained to me their hardship position. Can you explain to me why it does not meet the hardship in your opinion?
Pardon me one moment, I want to get the code. I thought I had it with me.
Sure. And while I'm-
Kamaria Pettis-Mackle from the City Attorney's Office, while he's grabbing that, can Mr. Chair, just for the record, acknowledge the receipt of the reports and the letters of support regarding this application?
Yes, we have read the letters of support. We have been presented what has been given to us. We have been given the reports.
And the doctor letter, and the engineering report.
The doctor letter, yes. We only have one copy of that, but
You already have.
do you, Ms. Pettis-Mackle, we only have one copy of this letter, that one, I think. We only have one copy of that.
Yes, sir.
Do you
That's-
need those back for the
Yes, sir.
the original? The others are copies, correct?
Correct.
Okay, let's just make sure she gets those back.
I'll grab it.
Okay, all right. Okay, well, okay.
Yes, sir.
Sorry, Mr. Randolph, please.
Quite all right. Yes, sir, Mr. Feldman, you were asking me as to the hardship criteria number 1.
Yes, as concisely as you can so that we
And,
can
well,
understand
it is very concise. The alleged hardships or practical difficulties are unique and singular with respect to the property or with respect to a structure or building thereon, and are not those suffered in common with other property structures or buildings similarly situated. No evidence in the record to prove that. They're trying to shoehorn an ADA case, which is completely illegal, into a variance case. Again, we're very sympathetic to that situation, but it's not a unique issue. Build the pool at 5 feet, you can make it work. I would like to inquire of Mr. Hendrick, because he provided some testimony in Mr. McElhaney's rebuttal. I have a brief question to ask him.
Ms. Pettis-Mackle?
Kamari Pettis-Mackle from the City Attorney's Office. If Mr. Grandoff is asking for additional time to ask questions,
No, what? He put on Mr. Hendrick a second time to
Well,
testify.
That- those
no,
were
no, sir,
questions.
we were asking
Oh,
questions
question of
of
the
him.
board.
yes.
Yes.
Fair enough.
I'll tell you what, Mr. Grandoff, why don't you tell me the issue that's bothering you, and we'll see if it's something
Okay,
that we want to ask about for Mr. Hendrick.
Okay. It seems to me that 5 feet is better than 3 feet when you're trying to build a swale to drain a pool that is already threatening to put stormwater drainage on my client. 5 is better than 3.
Okay,
And I believe
fair enough.
Mr.
I
Hendrick would
heard,
agree with that.
I heard testimony from Mr. Hendrick about that specific issue. I don't personally have any questions about that from him. I understand your position. If any of the other board members have questions on that subject, I'll allow them to ask it. Okay? I'm done with questions. If any other board, I feel like I've monopolized it, so if any other board members have questions, please ask them now.
All right, Mr. McElhaney. Hardship criteria number 1 says, well, let me just, I guess, start out with this. Your client's property looks to be about 21 feet from Arawana Avenue. Can you tell me about how far the other properties on the street are from the street? Like how far they're set back from the street?
I don't know. Do you know? I don't know what the other properties are.
Okay.
I can show you how this relates to the off-site property that Mr. Grandoff is talking about.
Sure. Yeah, I mean, that might be helpful.
Here is the tool's accessory structure.
Okay.
It's about 6 inches off of the Crafts property line.
Okay, thank you.
And
I was more interested in the front setback and how,
the front is 25 feet. They meet the front criteria. We also have a grand tree in the front that prevents us from doing anything. It's pushing the allowable remainder. It's pushing it back.
okay. And then I have a quick question for legal. So we heard a statement this evening that said that, the hardship criteria, that we're supposed to look at them in order 1, 2, 3, 4, 5. Is that how we're supposed to review the hardship criteria? I always thought of them as factors.
Kamari Pettis-Mackle from the City Attorney's Office. They are factors. There's no provision in the code. There's no provision in the rules of procedure on the specific order in which the board is supposed to consider the hardship criteria. It's just the board shall consider the following criteria.
Okay.
And that's it.
Okay, thank you.
Okay. I don't see any other questions from the board, but now's your chance if you have them. No? All right. Mr. McElhaney, you have 3 minutes for rebuttal.
Could I ask you a question first, sir? Did I satisfy the answer regarding the criteria for the hardship and practical difficulties?
I have all the information I need at this stage. Thank you.
We've tried to work these various issues out, and we seem to continue to reach an impasse on that. One of the things, and I'm going to show you a diagram here, one of the problems is that the tools have created their own problem. Here's an aerial photo, here's a front photograph of what they've done in the front. This was what they had, this is what they built. So they have created their own drainage problem. They are covering 74
Can you please zoom out a little bit? We can't see it all. Thank you.
They have covered 74% of their property. We can't find a permit for that driveway. We can't find a permit for the accessory structure, not the old one, but the additional accessory structure that they built. So, I mean, what we're trying to do is we've guaranteed them, we know from the city and the Crafts have committed to putting in either an under drain system or a shallow swale. But we prefer the under drain system because it doesn't silt in, it doesn't get filled in with grass and then overflow. It still has its capacity for drainage. And we have prepared in the original report, we showed a diagram exactly how that would function. So when somebody comes up here and says, hey, we're flooding, you've created your own hardship. I mean, there is no reason for us to address drainage before we do something, and we're going to excavate, at least, if we get this approved, we'll be planning to excavate the rear and make the drainage work. Their post condition will be much better than the current condition. We've put on the record that the structural engineer said 6 feet minimum in terms of separation from the main structure, which only leaves us either 4 or 3 feet in the back, which we're requesting the 3 feet setback to make that happen. You asked about the front of the house. We're at 25. We're more than 25 feet. We're at 29 feet. Let's see. Because of the tree. So the house did get pushed back because of that, leaving a much smaller area in the rear. I believe that we have met the criteria with respect to the hardship. I mean, we have hardship and practical difficulties. We've demonstrated that we have no other place to go. I mean, 3 being better than, or 5 being better than 3, it's an opinion. The engineers have said they can deal with that, and we have that in your report. It's by our civil engineer. He's gone through all the criteria. He knows what the code is. The code also says that you cannot adversely affect anyone else's property. So I mean, to assume that all of a sudden that's going to hurt somebody, I don't see where you get that from. I don't see it. We've been through this process regularly. I see you all regularly. It's not in our habit to come up and say we're not going to meet the code. We have too many people watching, and I'm sure that Mr. Grandoff's clients will be watching to make sure that it's built correctly. We would respectfully request your approval. I mean, I think that we've gone through the criteria. We're not adversely affecting anything off-site. It is in keeping. I mean, that.
Mr. McLeany, are you wrapping up?
Yes, sir. I'll be happy to.
Thank you.
I think that I didn't realize that we had to resubmit the original documents that were from the other hearing. But you have a very large report that goes through.
Mr. McLeany, we have the.
That's fine.
We have the record.
You have a very large report. You have an addendum which was done after that to follow up on questions that were raised by Mr. Grandoff and his client.
Thank you, sir.
The 2 items you just showed the board.
If you could just give us 1 second, Mr. Chair, please.
Sure.
That one?
That one. And the front yard photograph of the Craft property. That one's fine.
That's the one that.
Oh, the tree?
You had a photograph of the tree and the Craft.
That was in the previous submission. That's not a new.
But you've submitted into evidence.
Yeah, that's fine. I'll show it to you. Let me get to it.
Yeah, you sure will. I have a moment to review this, Mr. Feldman. The reason is he's entered new evidence in on rebuttal. I have a right to review that evidence before it's considered.
What evidence was admitted in rebuttal?
These 3 documents that he's flashed in front of you here
They
that
were
you,
previously submitted, John.
but you're
Okay,
asking the
well,
board.
give him a moment to look at it and make sure that in fact they are part of the record. Ms. Pettismack, are you working with them to make sure that, or to confirm that they are part of the record? Do we know that those are part of the record?
Kamaria Pettis-Malco from the City Attorney's Office. I'd ask any documents that were presented from both the petitioner and the public be received for the record of this hearing.
Okay.
Okay.
If in fact new documents were submitted during rebuttal, would you recommend that we give Mr. Grandoff another minute or two to talk about them?
If that's the pleasure of the board, but keep in mind that this is the petition, the request, the variance request is from the Crafts. And if that's the pleasure of the board, then I would ask that Mr. Michelini have the final.
Oh, absolutely, absolutely.
I agree.
Yeah, why don't we have a motion? Mr. Grandoff, is it your intent to talk about these documents?
And only these documents. I just want them authenticated
Okay.
and I have a few questions.
I would ask that, well, you don't get an opportunity for questions. If you want to talk about them,
Okay.
you can talk about them. And we'll give you additional time if the board makes a motion to open up the public hearing for
Okay.
additional time.
Okay.
I move that we reopen the public hearing to allow Mr. Randolph a little bit of additional time.
I'll second that.
All
Can
right,
you
Ms.
please state in your motion how long?
To give Mr. Randolph 3 minutes of additional time.
Plenty of time.
Okay, Mr. Grandoff. And then
I'll
Mr.
second.
Michelini will get 3 as well. Fire
Thank you,
away.
Mr. Chairman, if I may. This first item, I have seen it, I've not seen it as it's been colored, but this is a survey of the Crafts property. And let me show you, it shows that, excuse me, let me go, here's George Avenue.
Can you just clarify, Mr. Randolph?
I'm sorry, Tools property.
Okay.
Tools property, made a mistake. This is the Tools property, here's George Avenue. Please notice that the elevation on the Crafts property is 20 feet and change, and the closest elevation on the Tool property is 19.86, right here, very, very wet spot. Second, Mr. Michelini points this to you to say that they set the house back to preserve the tree. That has nothing to do with the competent substantial evidence test that you have to weigh tonight. So what? It's a big so what. Number 3, whatever my clients have done with their property is, again, not competent substantial evidence for you to consider, especially when you have this evidence that proves that their property is almost 6 inches lower than the Kraft property. I have no further questions.
Mr. Michelini, is there anything you'd like to say about those issues?
I would just say that if you come in and you argue hardship and you argue that somehow one property is affecting another property, it sits in a bowl. So the drainage that they're creating on their own property can't go anywhere else. It cannot go off-site. We've already said we're going to deal with all the drainage on our site and ensure that it does not impact them. I don't know what else I can tell you. When one of the board members asked me about the front yard and what the impact is there, I responded to that in my comments. So I think that we've clearly demonstrated that we've met the criteria. We do need some relief, and whether it's a 3-foot setback off of the property line or 5 feet, you can mitigate that with engineering, and our engineer has said you can do it. So you have to weigh that against opinion, and we have the civil engineer and his testimony. You have to, I think, you have to accept that at face value and say, yes, we agree. The civil engineers looked at it, the Crafts have committed to it, and it will be dealt with at permitting. Thank you, sir.
Thank you, Mr. Michelini. All right, with that, I will close the public hearing and open it up for a motion from the board or a board discussion. Pastor.
I think this case is pretty simple. This is not a unique and singular property. It's 50 by 100. Pools are allowed by the zoning, but they're not a right. If you can build a pool within the zoning requirements, then you can build a pool. Pools of a certain size are not allowed by zoning. If you need to build a smaller pool, you can build a smaller pool. There's nothing about this property that's requiring this. This is a desire to have a 10-foot wide pool when they can only fit an 8-foot wide pool with the rear setback and the distance required from the house. They make commercial hydrotherapy pools that are 8 feet wide, so I haven't heard any testimony why it has to be 10 feet wide, other than they would like it to be 10 feet wide because it's better for hydrotherapy. But I think that the commercial market would argue that. So there's vehement rear neighbor opposition, which is the most directly affected neighbor. There's nothing unique and singular about the property in question. A pool can be built within code at a smaller dimension than what's being proposed. I don't see a hardship for us.
So I don't know, the way I've synthesized all the information that we received is a little bit different than how you synthesized it, Mr. Pastor. I hear that, the applicant is, has a property that has a small backyard, which, although, as you point out, maybe not unique and singular in the general area, like could be unique and singular to this property. Mr. Michelini, I think, kind of alleged that the property was, that the structure on the property was further back than, it otherwise could have been. And hardship number one does, address structures located on the property. But, the biggest, the most important testimony, I guess, I heard was that, that the neighbor didn't oppose the pool specifically. Like, it opposed the impact that the pool was going to have. And I keep hearing that the code, addresses this, that the applicant has agreed to, mitigate any sort of adverse response that the pool, creates with respect to the drainage. So I am interested in what the other board members have to hear or have to say, but I am leaning towards approving this application.
Mr. Farrell had a comment. Mr. Farrell?
I'm ready for a motion to approve as the builder on the board before I get shut down by legal.
Before we get there, I think there, Ms. Hurtak wanted to have a little bit more discussion on the
Okay,
point.
well, I feel that they have in fact proved that there is a need, that there will not be any substantial impact on the Tools property. And in fact, I do know that when it does go to permitting, that the city of Tampa, in its plan review, will design it. So, and how specifically that drainage rule reads on the ground is for every square foot and inch that you change drainage with a construction element, you have to take that, the drainage you displace has to be then taken to the street and discharged. So that pool's going to be covered with deco drain, and that deco drain's going to be tied into 6-inch black pipe, and that's going to run down one side of the road, and it's going to bubble up at the street. I know for a fact in that area of Palmacia, at those older 50 by 100 foot lots, the city will not allow swales. They're practical and useless. As I said, they do nothing but fill with grass, and they aren't practical. When that pool, if it's approved, gets to be built, all of the drainage consideration, including the 6-inch differential between these folks' property and the Tool, that will be brought down so that there is not an opportunity for them to continue draining onto the Tools property. That's how it will be handled at permit.
Thank you, sir. Why don't we hear from Ms. Hurtak?
Okay, I have a couple of points. First of all, this request is to reduce the rear yard setback. It has nothing to do with drainage. It's just a simple request for a reduced rear yard setback. So the drainage doesn't matter to me at all, because that's not what I'm asked to look at. And when I look at these hardship criteria, there's no practical difficulty. Now, if they had actually, the tree in the front yard's interesting, but they produced no evidence. So I can't use the tree because I don't know if the house was moved back because of that. So we can't look at that. That can't be considered. I absolutely don't see how this is approvable.
Okay.
And yet we approved it 4-2 so many months ago.
I understand what you're saying, Mr. Farrell. And, more evidence has been presented before us this evening. We need to consider all that evidence. We need to focus on the issues at hand. I tend to agree, at least with one point for sure with Ms. Hurtak, which is that I don't believe drainage is really an issue here. I understand that it was primarily an issue that was introduced by the opposition, but I really don't see drainage as the problem, because I do think the city deals with drainage. I think the issue that needs to be focused on is one that's been touched upon by a number of the board members here, which is, has the hardship criteria been met to address the 3-foot setback and the pool issue? And I'm not going to give an opinion on that. I just think that that's the issue that we need to address. So if there's more discussion to be had, let's have it. If not, let's have a motion and see where we can get this thing. Does that make sense? Who would like to make a motion?
Motion to approve.
Mr. Farrell, go ahead. Mr. Farrell.
Yes, sir.
Before you start,
Right.
for purposes of this one, it will be particularly important to address the hardship criteria in specifics. Fire away.
Okay. Move that for the variance request for case VRB 20-60, the property located at 1508 South Arawana Avenue, be granted as depicted on the site plan presented at the public hearing for a request to reduce the rear yard setback from 5 foot to 3 foot to construct an in-ground pool based upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria in section 2780 of the city code, specifically that by locating the pool in the area that it is located, it facilitates the use of the pool for the benefit of the owners who are handicapped.
Mr. Farrell, can you provide additional information?
Yes, and the reason I say that is because when you look at the dimensionalizing of what it takes to open the rear doors, which were part of the house when the client bought it at 3.0, when those doors open and you have to transfer an elderly woman from a wheelchair into a mechanism that then has to turn around and put her in a pool, you need enough space to do that. And additionally, the engineers have commissioned a study and believe that encroaching the pool any closer to the main structure than 5 or 6 feet could potentially cause structural issues for the main structure.
I'm inclined to second that motion with 2 amendments. The first being that we acknowledge that the structure located on the property is such that there's a small rear backyard, and second, that we have heard no evidence of neighbors objecting to the variance based on the location, based on the reduced setback, and haven't heard any objections based on items that are not otherwise going to be addressed during the permitting process.
I don't think we can make the comment that the neighbors don't oppose based on the setback. They're opposing the setback.
Okay.
And that's not a part of the hardship criteria, whether or not there's a neighbor objecting
Okay.
to.
But I certainly don't mind
Oh.
adding that.
So maybe the amendment should be, the variance won't substantially interfere or injure the health, safety, and welfare of others, as,
Other effect, yes, that the granting of the approval, that the stated conditions does not affect the health, safety, or welfare of any encroaching, any neighbors.
Mr. Farrell, do you accept the amendment suggestions by,
Yes, ma'am.
okay. Is there a second to the motion?
second.
All right, we have a motion by Mr. Farrell, seconded by Ms. Decker. All those in favor, say aye.
Aye.
Can you raise your hand?
All those opposed, nay.
And can we, Mr. Chair, can I have a motion a new motion regarding the denial of the variance request, please? Just for the record, I need the board to make a motion
Okay,
in opposition of the variance.
all right.
I will move that the variance request for case VRB 2060 for the property located at 1508 South Arwana Avenue for a reduction in the rear yard setback from 5 feet to 3 feet be denied due to the failure of the petition to meet its burden of proof to provide competent substantial evidence in the record and at this public hearing of a necessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 2780 of the city code. Specifically that this is not a unique and singular site, that a pool can be built at different dimensions.
Is there a second?
I'll second.
Okay, we have a motion to deny by Mr. Pastor, seconded by Ms. Hurtak. All those in favor of the denial, say aye. 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 All those opposed? Nay.
Nay.
Thank you, Mr. Chair.
All right, your petition has been denied. If you wish to appeal to City Council, you have 10 days from the date of the written order. Yeah, that's what we do. All right. Just popping out like out of a birthday cake? Yeah. All right. Are we ready for the next case?
And then tap it to turn it.
Let's go.
All right, Jane, can you hear me? Oh, okay, there we go. Jane Madu for Development Coordination, and this is VRB, the case is VRB 2193. The owners, property owners are Anita and James Rocha, and they will be representing themselves. The property is addressed at 4601 West El Prado Boulevard, and the variance request is to reduce the corner yard setback from 15 feet to 12 feet in order to construct an attached carport to an existing single-family residence. And the code section reference is section 27-156C. This is an aerial of the property, a corner lot at the intersection of West El Prado Boulevard and South Hesperus Street. This is a section of the, this is a picture showing the scope of work where the carport is intended to be located. Site plan showing the proposed area of work. And the board will grant a variance subject to the criteria in section 27-156 80. And staff is available for any questions.
Okay, petitioners are here. Come on forward, state your name, your address, and please let us know if you've been sworn.
They have not been sworn.
Okay, well then let's swear you in. And you'll still get to tell us if you've been sworn.
Please raise your right hand. Do you solemnly swear or affirm that the testimony that you're about to give today is the truth and nothing but the truth? Yes. Thank you, sir.
All right, good evening. Name, address, and confirm you've been sworn, please.
Name, address, and what?
Confirm that you've been sworn. We just watched it, but you'd get to say for the
Okay,
record that
okay.
you've been sworn.
My name is James Rocha. I live at 4601 West El Prado Boulevard, and I have been sworn in.
Great. You have 10 minutes to present your case and tell us about your hardships.
All right, sir. I'm here tonight to, on behalf of my wife and I, to ask for a variance along for the corner side setback of 3 feet to allow us to build a carport attached to our home on the east side of the house. The reason for that is my mother-in-law, who is 87, recently came to live with us. She has very poor vision. She's had 5 cornea transplants, and we take her to a lot of doctors' visits and so forth. We are now just recently obtained a permit from the city of Tampa to put in a 2-car driveway and get rid of the 70-year-old driveway we have. And the carport would allow us to be able to get her in and out of the car safely in inclement weather and things of that nature without her possibly falling, which she has done before. And so that's why we're asking for the variance to be able to build the carport on top of the new driveway.
Okay. Does that conclude your presentation? Is there more you'd like to tell us?
No, sir, I can't think of anything else at this point.
Okay. Well, why don't we open it up? Is there anyone in the audience who would like to speak about this petition? Seeing none, I'll open it up for board questions. Mr. Pestor.
Could you please show us a plan with the dimensions and the distance from the street and things like that?
You're gonna put your documents that you're showing right here.
Okay.
And then when you put it right here, the board will be able to see it.
Okay. This is a plan that was approved by the city of Tampa in getting a permit for the driveway. I don't have anything that shows the carport, but the drawings that I have from the engineer show it as being 22 feet by 22 feet. That's this one here.
Okay.
I don't know if you can see that.
Okay, so 22 by 22. Can you put the other plan that you just had back, please? The one with the driveway?
Yes, sir.
So it looks like the distance from the house to the property line is 33 feet, and then from the roads, another 22 and a half.
Right.
So this would be 22 feet into the 33 feet right off of the house, you're saying?
Yes, sir. It's attached right here
Okay.
to the fascia.
So approximately 11 feet from the property line.
Yeah, well,
And Kamaria Pettis-Malco, for the record, I believe staff has a different site plan that shows the
Okay.
carport, and if staff could provide that information, please.
That would be great.
Sir, excuse me.
Okay, so 22 feet off the house, 12 feet to the property line, it looks like. So basically what we just saw with a foot variance. And then, you know, whatever the setback is to the road, which would look like it was about 22 and a half feet. Okay, that's all I wanted to know.
Mr. Rocha, the other thing that I noticed in the design, this also gives you the opportunity now to get covered access into the back of the house, does it not? I saw the little offset of the covered area on that southwest corner in that drawing. So you have no covered opportunity whatsoever now to get into the house, correct?
Well, sir, we use the garage to be, as our entry. Always have because of the driveway being there. So that kind of, we do have a front porch that faces El Prado, but this is where we go in.
This is your rear entry, this is
Right.
an opportunity to get covered.
Yes, sir,
Yes,
and that's
to
what
get
we're trying to
covered way,
do for
right.
my mother-in-law, so.
Okay.
I have a question for staff. So we heard testimony that this is a corner lot. If this lot were not a corner, like if it were just on El Prado and there was a neighbor on both sides, what would the setbacks be?
7 feet?
Okay,
Side yard.
okay, that's all I needed, thanks.
Any other questions? No? All right, Mr. Rochi, you have 3 minutes if you'd like to tell us anything else or address anything that, any of the questions that were asked of you. If not, Mr.
I'm sorry.
Farrell,
I have
you have
one
another question?
The 3-foot expansion, there, when your engineer did the, is the extension of the 22 feet, is that's the outside edge of the carport? Is there a structural post that lines up with that 22 feet? Or does that structural post sit back from the face? Because if it's an overhang, is it even a variance request? It's still a variance request. Okay. So it doesn't really make any difference where that post is. It can't stay on the setback line and stick into the, okay.
Because if you could hang over your neighbor's property.
We could hang whatever you could physically hang.
Mario Pettis-Mackle from the city attorney's office. I'd ask for staff to clarify
Yes,
the
ma'am.
questions, if you guys have questions, for staff to clarify that for you.
Well, I was just trying to clarify with staff that if the structural posts that held that carport were behind the setback line, would that change the request if only the eave and gutter were to extend into the setback?
Can you come to the microphone, please, since it's being recorded?
Jane Amadu, Development Coordination. Technically, it should not get into the setback.
Into the setback.
It should be out,
Yes, ma'am.
either on the line or within the setback.
All right, any other questions? Last chance? No? All right. Mr. Rochi, you have 3 minutes for rebuttal if you should need it.
Well, I would just ask that you give us a consideration of this because we've been here 37 years. We've not done anything, to ask you guys for any variance. But also the structure itself is not unlike others that we have in the neighborhood, and it's not going to impose on anybody. The drainage, so the roof will be at the end of the structure going down a downspout, which already exists at the corner of the house next to the garage. We're eliminating that downspout and then putting it out at the end of the carport. The water will go down the driveway into the street, similar to what happens now. So we're not impacting anybody or anything off of our property. And I don't have anything further. I appreciate your consideration and your time.
Thank you.
Thank you.
All right, I'll now close the public hearing and open up for a motion or discussion. Mr. Pastor.
I'll make a motion. I move the variance request for case VRB 2193 for the property located at 4601 West El Prado Boulevard be granted as depicted on the site plan and presented at the public hearing for a reduction in the corner yard setback from 15 feet to 12 feet with encroachment for eaves and gutters based upon the applicant presenting competent and substantial evidence and in the record in the public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 2780 of the city code. Specifically that the 3-foot encroachment is still 12 feet from the property line. It's on a corner lot, so it does not immediately abut a neighbor. We heard testimony this is a similar condition throughout the neighborhood, and this is a relatively typical size for a double carport.
Thank you. Do we have a second?
Second.
Thank you. All right, we have a motion by Mr. Pastor, second by Mr. Farrell. All those in favor say aye. Aye. All those opposed? All right, motion is approved, 7-0. Have a good evening.
Thank you all.
Next case, Ms. Barnes.
And that's VRB 2194.
Ms. Pettis-Mankle, do we need for the record that one of the board members is?
Kamaria Pettis-Mackle from the City Attorney's Office. Just for the record, Mr. Murphy is recusing himself for VRB 2194, and he has filled out the form to notate that for the record.
Thank you. All right. Fire away, Ms. Barnes.
Good evening, Anastasia Barnes. The next case before you is VRB 2194. The applicant and property owner are Charles and Megan Goddard. The property address is 303 West Villa Rosa Street. The zoning is RS50, and the variance request before you is to reduce the minimum separation between an accessory and principal structure from 5 feet to 3 feet and increase the allowable accessory height from structure height from 15 feet to 20 feet. And it's for an existing treehouse, 20 feet in height. This is the aerial of the subject property and surrounding zoning. And the site plan provided by the applicant, as well as pictures provided by the applicant of the treehouse. The board shall base its findings on section 2780, and staff is available for any questions you might have.
All right. Is the applicant here? All right, come on up. State your name, your address, and have you been sworn?
I have.
Great. Name, address, and confirm that, please.
You got it. Good evening, members of the board. My name is Charles Goddard, address 3303 West Villa Rosa Street. I live in Bayshore Beautiful along with my wife and 3-year-old son and our 1-year-old daughter. We live on lots 19, 20, and 21 of Oak Eller Block 8 in Bayshore Beautiful. This variance request relates to a treehouse, as you've seen some of the pictures. It would be a treehouse in our backyard on lot 21. Specifically, the request is, as you heard, to increase the accessory structure maximum height from 15 feet to 20 feet, as well as to reduce the minimum separation between an accessory structure and the primary structure from 5 feet to 3 feet. And before I get into the presentation, I just want to read a quick excerpt from Tampa's comprehensive plan. Looking to page 179, children are the community's greatest asset. How well they thrive towards becoming active and concerned citizens in the city they were raised in and don't become another city's asset will be determined by how well their city has provided for them. When the pandemic hit, kids' social interactions drastically changed, as any parent can attest. Since March of 2020, the safest place for our kids to play has been the backyard. Tree houses are fun. My kids love being outside, and we have oak trees, so a tree house was a no-brainer. But before building the tree house, I tried to do my due diligence with the city of Tampa. It's important to me to follow the rules and to do what's right. On October 2nd, 2020, I called Construction Services and asked if there were any permit requirements to build a treehouse. Construction Services said no permits were required, provided it was a residential treehouse, that I simply needed to contact zoning for any further questions. So I emailed zoning and asked them what the requirements were to build a treehouse. In reply, zoning advised that a treehouse is considered an accessory structure and that the only requirements were a 3-foot side and rear setback, that it had to be under 600 feet, and that I needed to obtain a building permit from Construction Services. I've got the email, happy to provide it if you guys would like. So even though Construction Services had already said no building permit was required for the residential treehouse, I researched the various building permits online and it looked like a site plan was required. So I didn't have a site plan. My only site plan was hand drawings. So I called zoning back and said, what kind of site plan is required, if any? Their reply was simply to call construction services. So I called construction services again, and they now explain that as long as the treehouse footprint was less than 150 square feet, then no building permit was required because of an exemption in Tampa's code. Construction services also recommended that I consult with an arborist regarding the health of the oak tree before building the treehouse. So, to satisfy the permit exemption, we revised our treehouse design to make it less than 150 square feet. Then, to comply with the side and rear setbacks, we changed the treehouse location to the oak tree behind our house instead of the oak on the east side of the house as we initially planned. Then, to comply with construction services' arborist recommendation, and because safety was our primary concern the whole time, we of course gladly retained a professional arborist to assess the oak tree. The arborist inspected the tree, said it's healthy, and that a treehouse would be fine. He even commented when I showed him the structural hardware that we ordered from Pete Nelson from Treehouse Masters. I don't know if you guys have seen him on TV, but he said that, that this was the best way to attach any kind of a structure or treehouse to an oak tree because it's designed to allow for the continued growth of the oak tree. So ultimately, we did everything that the city asked us to do. We complied with the side setbacks, the rear setbacks, the size, the permit exemption. We got the arborist out. He said everything was fine. So once we got the all clear from the arborist, I built the treehouse. And that was over the 2020 Christmas break and weekends in early 21 of this year. So I thought everything was fine. Then on February 22nd, while my wife was at home by herself, code enforcement shows up unannounced with the badge and posts a notice of violation to my front door, threatening criminal prosecution for not having a building permit. So, of course, what's going on? I call the city and explain, look, the only reason I didn't get a building permit was because you guys said I didn't need to, and that satisfied the permit exemption because the structure is indeed under 150 square feet. So, needless to say, by the end of the day, code enforcement had actually, they cleared the inspection, said sorry for the inconvenience, and passed it, case closed. So, a month later, in March, code enforcement shows up again, this time in response to an anonymous phone complaint that the treehouse was attached to our house, which was simply false. So upon another inspection, the code enforcement again advised that the treehouse was code compliant. The case was passed and closed a second time. Code enforcement also recommended that I call Tampa's neighborhood enhancement manager, which I did, left a detailed voice message, but I never heard back. Then on May 19th this year, Construction Services left a voicemail telling me that in a few hours, all 4 division chiefs would be coming out to inspect the treehouse. So naturally, I was shocked and thought, how many bites at the apple is the city going to get, But my only concern was, the 4 division chiefs coming out, they're going to ask me to tear the treehouse down at this point. So anyways, I called the city, spoke to the chief building official, and he assured me that no one from the city was aiming to tear anything down, that this was purely a case study for how to handle tree houses moving forward. And so I said, okay, left word, met him at the house. We walked around, welcomed their inspection of every aspect of the tree house. I think they were surprised at the tree house. They complimented the design, the safety features. And then they pulled out an iPad and introduced me to Eric Cotton via FaceTime. And he was very pleasant, and he asked me to go through the variance process, and that's in part one of the reasons why I'm here tonight. Again, I've done everything that the city's asked me to do. So, one moment. When I was speaking to Mr. Cotton, I did express concern that if this is unfairly framed as asking for permission after the fact, when all I ever did was follow the city's instructions to a T. And I don't want to digress too much, but Mr. Cotton certainly agreed that was not the case. In terms of the other hardships and practical difficulties that support the variance, in one of the photographs submitted in my application, I don't believe it was shown earlier, but you can see clearly that the oak tree that we decided to move towards to comply with the side setbacks that we were advised of, that particular oak tree behind the house, it steeply angles towards the house up until a height of about 11 feet, above which it grows relatively straight up. So the platform had to be built at that height to allow for the proper and safe construction of the support beams, as well as proper structural loading of the platform. And then, because of the structural knee braces that we used to be less invasive to the oak tree, the platform had to extend to 3 feet from the rear of the primary structure. Beyond ensuring that the treehouse was safe, we also took great efforts to make it aesthetically pleasing and consistent with the surrounding neighborhood. And I won't get off track too much, but all of the surrounding neighbors, well, most of the surrounding neighbors have kids. All of the surrounding neighbors, to my knowledge, are happy with it. There's no objections. The kids love coming over and playing with our kids in the treehouse. Everyone's happy. Ultimately, this variance is consistent with the intent of the code. It's consistent with Tampa's comprehensive plan. The 15-foot height code was adopted for a typical accessory structure like a garage or a shed or pool house, boathouse. Tampa doesn't have a treehouse ordinance. Unlike a typical accessory structure, a treehouse is, well, it's located in a tree. In other words, if the height was measured from the base, the 15-foot height setback would easily be satisfied. The 5-foot separation code was designed to prevent fires originating in the accessory structure from affecting the primary structure. Unlike a garage or a shed full of gasoline, pool chemicals, and other dangerous substances, this is a treehouse. It's for children. No one's going to occupy it, and there will never be any flammable substances or dangerous chemicals in it. At the very worst, there might be a melted popsicle or some non-toxic bubble solution that gets spilled. The variance is also consistent with Tampa's comprehensive plan. Consistent with Neighborhood Policy 1.13, the treehouse is family-friendly and fosters community pride. Consistent with Neighborhood Policy 1.3.5, granting this variance is an opportunity to enhance the assets that identify our neighborhood, including people, trees, and large yards. Consistent with Neighborhood Policy 1.3.6, the treehouse is usable by people of all ages. It encourages interaction, and it instills a sense of pride, and it's family-friendly. For these reasons, we respectfully ask that the board grant the treehouse variance. Thank you for your consideration.
Thank you. I will look behind you and see if there's any members of the public who would like to speak on this application. It looks like there are none.
Mr. Chair, Kamaria Pettis-Mackle from the City Attorney's Office. There were, hold on.
If you're going to talk about pictures that were submitted, I was going to ask a question about that. You know?
No, I'm sorry. I was there. I believe I have 4 or 5. 1, 2, 3, 4 letters of support for the variance.
Correct. I omitted that. Yes.
Okay. I just want it to be acknowledged.
For the record, we have 4 letters of support. Were there any letters of opposition that you're aware of?
I got one in my email.
There is 1 letter of opposition, and the remaining, that is correct. I
Okay.
apologize. There is 1 letter of opposition, and the remaining are in support.
Okay, thank you. And that is acknowledged for the record. All right, so I'm going to open it up for board questions. I had one for Ms. Barnes. The petitioner referenced pictures. I only saw 1 picture in our packet. Were there others?
It should be 4 or 5.
Anastasia Barnes. So there are several pictures submitted by the applicant to my email. I always ask the applicants for the PowerPoint. I thought the 2 best pictures available were the ones provided, hence why I put it in the PowerPoint. However, if the applicant has those pictures, he can submit them into the record as well.
I didn't realize I needed to bring them after submitting the
Okay.
application.
So,
I have a picture of the oak tree showing the angle, if that helps, but it's black and white and small.
That's fine. Anything you have is helpful. In addition, you referenced an email that you had with, I do see some emails in the petition. I don't know if the emails you have differ from those, but if you want to provide those and submit those for the record, if you would give those to Ms. Barnes, she'll accept them as part of the record.
Certainly. That's the email and contemporaneous notes that I took while I was speaking with Construction Services and Zoning.
okay. Would you like me to place this on the overhead projector, or would
The
you
photograph?
No, this is notes from, our emails and notes from the applicant.
We do have some notes in here. I just want to make sure it's part of the record, that's all.
Okay.
And then if you want to get the photo on the Elmo, whatever that is. Whoop, yeah, we have that one. It's upside
Okay.
down, but we have it.
Whoops. Okay, so that shows the angle of the tree up to the height of 11 feet. And then as far as the email that we're going to submit into the record, do I give that to you?
Give that to Ms. Barnes. And, go ahead.
Ms. Barnes, is there a way that you could put the pictures from your presentation back on, because we don't have those?
Yeah, I
Give me
guess I'm
1 minute.
particularly interested in how the front of the house, if you can see it behind, or the height was interesting to me.
Sure. Yes.
Since there have been all these officers out, is there now being a treehouse code looked at right now? or-
I am not aware of one. You know, that's something to be discussed further.
No, Kamaria Pettis-Mackle from the City Attorney's Office. Ms. Johnson, are you referring to the code case? And if so, that's a separate matter that is not going to be discussed tonight. Are you talking about the code case? Or are you talking about a tree code ordinance?
I'm talking if there are any codes pertaining to a tree house.
Can you turn your microphone on? I can't hear you.
Okay, now it's on. Sorry. I'm talking about if there were any codes relating to tree houses that are in the process of being worked on in the city.
I'm not aware, but that's separate process for the department, for the city to look into, not a part of this.
But there's nothing now?
No.
Okay.
Any other questions for the board? Mr. Pastor?
Mr. Goddard, is the house as it exists still under 150 square feet?
The treehouse, yes.
Yeah, okay.
Specifically, it's 144 square feet.
Okay,
And we
so,
purposely designed it that way.
so then I have a question for Ms. Barnes, please.
Yes.
So then what is Mr. Cotton's basis for the need for the variance? Because doesn't it still not require a permit?
Correct, but it still has to meet zoning specifications of the code. So,
Does any building under 150 square feet have to meet?
correct, yes.
Okay, thanks.
All right, do we have any other questions for the applicant? Mr. Farrell, no?
Nope.
Okay. Oh, all right. Well, no other questions, so we'll turn it back to you. You have 3 minutes for rebuttal, should you need it.
Sure, and I'll just make this brief. To my knowledge, the only opposition to this originated from a neighbor to our east who has, over the last 3 months, moved out, did very well, made a profit, good for them. The new neighbors, to my knowledge, are very happy with it. All of the surrounding neighbors, again, have kids. Everyone's happy with it. The only person, I wish I had more photos, but looking to the right, I don't know if you can see these two photos that are up on the screen in front of me. But the neighbor behind me is the only neighbor that has a direct view of that treehouse. Their 6-year-old is a good friend of our son. Their 1-year-old is a good friend of our daughters. We're family friends from school years ago. They have no opposition to it. In fact, they're one of the people who signed the letter of support, if you look to the application file. But again, to my knowledge, the only known opposition originated from someone who is no longer in the neighborhood. All of the other neighbors are friends. They compliment it. They talk about it. Everyone's happy. Again, it's a subtle, I know it looks big and daunting in those photos, but the color, it almost blends into the sky when you look at it. It's built safe, it's built well, complies with the code, it complies with the intent of the code, and we followed, I talked to zoning and construction services on no less than, 12 different times. In terms of the hardship or practical difficulties that run with the land, the tree that we went to because of our attempt to comply with the setbacks, the tree that we went to required us to put the platform at a slightly higher point so that it was safe. So, we've tried our best to comply with everything from, soup to nuts, and here we are tonight, and I thank you again for your consideration.
Thank you very much. All right, with that, I'll close the public hearing and open it up for motion from the board or board discussion. Does anyone have a motion? Mr. Farrell?
Sure. I move that the variance request for case VRB 2194 for the property located at 3303 West Villa Rosa Street be granted as depicted on the site plan presented at the public hearing for a reduction in minimum separation between accessory and principal structure from 5 feet to 3 feet and increase max accessory structure height from 15 to 20 feet as per section 2790. 290, excuse me, based upon the applicant presenting competent and substantial evidence into the record at the end of this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria as set forth in section 2780 of the city code, specifically that the applicant went extensively researched the possibility of doing the project with the city and found himself in the unenviable position of applying for something that he couldn't apply for a building permit for. So I also think that in light of the fact that it is almost a community-based asset among that neighborhood, that certainly bodes well for its purpose, and that's it. Excuse me, that's it.
Okay, do we have a second?
I'll second.
Okay. Motion to approve by Mr. Farrell, seconded by Mr. Pastor. All those in favor, say aye.
Aye.
Aye. Any opposed? No? All right, motion is approved, 7-0.
Thank you.
Have a good night. 6-0. Oh, I'm sorry, did I miss you? Oh, 6-0, because we have, thanks, math. Have a good night.
Mr. Chair, can you announce that we're in recess?
We're going to take a 5-minute recess.
Let the man pass through. Or affirm that the testimony that you are about to give today is the truth and nothing but the truth? Yes. Thank you. May I have a seat?
Anastasia Barnes, the next case before you is VRB 2197.
If we could have the visual department switch to the computer in the clerk's booth, we don't see the presentation.
Are they still working on that?
My bad.
Okay.
We're still seeing the board.
You have no others?
We don't see her presentation.
Let's see.
Is there any reason why we can't do the swearing in while we wait for this?
I'm sorry.
Did we did it? Oh, I missed it, sorry, okay. Did you not want to do it again? Do we want to do it again?
I don't think they want to get up again.
Thumbs good.
Okay, so we're having technical difficulties, so I can just do it from my staff report.
Oh, you can't even pull up your original PowerPoint?
No, something's going on.
She was working this earlier, I'm not sure.
Will it let me show the Elm?
Yeah.
But she just had her previous.
Oh,
So, let's see.
it's not. What about on there?
We can put it on here. What's on here?
Yeah. Okay, I'm gonna present it after and that.
Okay, that's on.
All right, Anastasia Barnes, Development Coordination. The next case before you is VRB 2197. The location is 2808 West Candy Boulevard. The applicant and agent is Mark Bentley. The property owner is Kojak's Holding Company. The variances requested before you are two separate, two to remove 2 grand trees, and there's another variance to reduce the required minimum retention. And this is for proposed development. Specifically, Section 27284.2.5 is for the grand tree removal, and Section 27284.3.1 regarding the minimum retention. There are 2 associated applications, a special use as well as a design exception that are listed in your staff report. And unfortunately, as you can see, we were having technical difficulties, but in your packet there was a revised site plan as well as 2 alternative plans that were provided. The board would grant variances for the grand trees and for the hardship criteria in 27284.25F for the tree removal, and then the retention would be 2780. Additionally, Natural Resources staff found the request inconsistent, and Stephen Eister with Development Coordination will be able to discuss his findings in the memo provided as well. That concludes my report, and I'm going to turn it over to Mr. Eister.
Ms. Barnes, do you have can you just for the record show the site plans, or do you have those?
I do, I believe I do have the site plans. They might be smaller in size, but let me try on the overhead projector to show that. So this is the site plan that was provided last week, revised site plan. This is the first alternative plan provided, and I actually need to flip it. And then I'll provide the other alternative plan provided. And these 2 were also included in your packet. There was also a revised arborist report provided by the applicant on September 6th that said it was revised on the 10th in Acela. So that revised report was in your packet as well. And I will let Mr. Eister explain his findings for the record.
Hello, my name is Stephen Eister, Natural Resources. So we found the plan inconsistent for a few different things. First off, the alternative site plans do show ways to preserve the grain trees on site and meet the retention percentages outlined in the code. Also, if you guys look at my memo, number one, mitigation trees cannot be paid into the fund. So if this does go through, they will have to come back for that. They can't get that taken care of in building or anything like that. They would need an additional variance to get through that. Also, with their plans, if you look at the square footage calculations of green space, they meet the 350 square feet per townhome, but as far as the VUA green space goes, that requirement is not met, along with that landscaping.
VUA?
The vehicle use areas, that's the road that wraps through the neighborhood. So with those things, we found the plans inconsistent. I had my evaluation. We got C6, C7s, which means the trees do need to come here for a variance, that they're not a hazardous condition. And I also have the tree table, which I'll pass around. And that information was pulled directly from the submitted arborist report, showing all the trees removed and all the trees being retained. At the end of the sheet, they have a deficit of 17 type 1 trees, which are your large shade trees, and 23 palm trees that they would have to replant back on site. And then I'm available for any questions.
Just wanted to clarify one of the things you said.
Yeah.
So you're saying that if the plan proposed was approved, the mitigation requirement, they would need a variance to pay into that rather than to place the trees on the site?
Correct.
And since that wasn't in the notice, then it can't be addressed at this time. It would require another variance. Okay, just wanted to clarify.
Yep.
Mr. Bentley, is it? All right,
Yeah,
if you
Chairman
would please,
Feldman.
name, address.
Certainly. Mark Bentley, 401 East Jackson Street, Tampa, 33602. I've been sworn. Before you start the clock on me, and just a couple items I'd like to go over, if you don't mind, Mr. Chairman.
Sure. What's at
Okay.
issue?
I've got a book, a composite exhibit book, and there's 6 copies up here.
Can you assist in reading that? We have somewhere that will handle it.
Have those been submitted into the record?
I don't know what they are, so.
Oh. Okay. Only got 6 copies. You want to share one? We'll share one. Okay.
Okay. And then just a couple more items. Just to correct the ownership, it's actually 2808 Gandy LLC is the owner of the subject property. And then, Mr. Chairman, I have an expert witness, and this is a little more of a technical matter. I realize per the VRB rules, I only have 10 minutes, but I'd ask for an additional 5. I'll try and do this as quickly as I can. The concern I have is the staff report, it sets forth the criteria for you to apply to our request, but if you notice on page 1, it cross-references different code sections like 284.2.5, 27156, and uses terms like reasonably reconfigured. Those are all in different code sections, which I've given you, and I'd like to go through those with you. So in order for you all to make a well-informed decision, I think it's pretty important that you understand these other code sections that you haven't been provided.
In order to give you additional time, we'd have to have a vote on that to allow you additional time.
Yes, sir.
Why don't you cover what you can cover? I have a little bit of leeway to give you another minute or so, and then if you find that you're in need of additional time, we can make that request at that point and have a vote on that
Okay,
issue.
so my game plan here is to go over some of these code requirements, explain a little bit about the project. And one other point before I formally get started is Mr. Eister indicated that we'd have to come back for another variance. We dispute that, so we can save that for a later date, but we don't think we do.
Okay.
Because we don't intend on paying into the city's tree trust fund to mitigate the removal of the grand trees. There's other options.
I'm going to go ahead and start your time now, and fire away.
I guess so. Okay. The proposed development consists of 21 fee simple attached townhomes on property zone general commercial or CG. The properties to the west and the east of the subject property are also zoned CG. The property is formerly known as Kojak's Rib House. Note that the city's comprehensive plan would allow 37 units on the subject property. However, the client's intent is 21 single-family conventional townhomes. Notwithstanding the numerous codes and regulations applicable to our client's proposed development, the only relief our client is seeking from the city of Tampa is removal of these two compromised grand trees located within the interior of the project. I'd also like to mention to the board at this point in time, we're withdrawing the request for the tree retention. It's our intent to meet code. We had requested to remove over 50% of the trees, and that's not on the table anymore, so we don't have to deal with that. Failure to allow removal of the trees will, per the site plan we provide the city to demonstrate there was no reasonable reconfiguration, would reduce the proposed project by 52% and 57% based on the two alternatives. Are looking at the entire property as a whole, it would be reduced by 73 and 76% if you look at the development potential in terms of entitlements of 37 units for the subject property. I take you to tab 1. This is important. The city of Tampa has a list of select arborists who it refers the public to based on their professionalism, integrity, and reliability. There are only 18 arborists on this list, as you can see, and to ensure our client was receiving the best advice, he retained 2 of the experts, former city employee David Riley and also Mark Hughes. Excuse me. Can you hold the time? Okay, thanks. And Mark Hughes is going to testify tonight. Both arborists have rendered very similar opinions concerning the 2 trees in question and believe that because of this condition, requiring to allow their removal would not impose an unreasonable configuration, or would impose an unreasonable configuration on the project. Tab 2 is the opinions of the experts. Mark will speak to that. Tab 3, let's take a look at that. This is survey the property. North is where my finger is pointing. The 2 subject trees are identified as trees 28 and 29 right here. They're both roughly 40 inches in diameter and have a canopy spread between 70 and 80 feet. Tab 4 is a site plan showing the trees impacting the units and the road circulation. We'll take a quick look at that. So here again, Gandy Boulevard is to the north. Here's tree 28. I don't know if you can see this very well. There, that's better. And then here again, it's tree 29, the 2 trees in question. Since they're located more in the centralized area, it makes it difficult to save the trees. Now, when the city reenacted its landscape ordinance in 2019, what it did, the city council was wise enough to put in its standards and criteria to determine what a reasonable reconfiguration consists of. Otherwise, what I think is reasonable may not be reasonable to you. So there are some standards and criteria to eliminate this arbitrary application of the code and the subjectivity associated with it. In tab 5, we have the board's charge. Is to determine under this code section whether the applicant has demonstrated that maintaining the trees would result in an unreasonable reconfiguration of the project. Reasonable reconfiguration is a purely objective standard under the new code. You don't have a copy of that code section, which I'll go through, that is now in the code to provide guidance and certainty to both the city and the property owner. Tab 5 is 27284 1.2.5 F4. It's page 4. If you go to the second page under tab 5, that's it, just tab 5. It says here, the board is to determine under B whether the proposed buildings can be reasonably reconfigured as defined in table 284.2.5, which you don't have, to preserve the grand trees. This table refers to section 2760, which allows administrative relief for zoning setbacks. So what this is telling you here that in order to save a grand tree, there's a section in the code, it's called a design exception, which would allow for nominal waivers in terms of the setbacks around the periphery or the boundary of the property that you wouldn't have to respect. You could they could be expanded, or you could encroach within these setbacks an additional few feet. And there's a formula, I'll go over that with you. Then C, under tab 5, is whether the reduction of required setbacks for the primary buildings as provided in section 27156, table 4-2, note 7, which you don't have, will allow relocation of the building sufficient to preserve the grand trees. So will relaxing the building setbacks save the trees? In our case, since the trees are centrally located, the answer is clearly no. So 27-156, table 4-2, I'll show you that in a second. And here again, that allows for some minor encroachment into the setbacks that surround the entire property in terms of the front yard setback, the rear, and the side. So the key term we're dealing with and standard for the board to apply is the objective standard of reasonable reconfiguration. Sections B and C that I just discussed provide relaxed building setbacks around the property boundaries with the goal being the preservation of the trees. And if one has to move a building more than allowed under B and C, then that's considered under the code a non-reasonable reconfiguration and is justification for the removal of the tree. Relaxing setbacks around the perimeter will have no impact on the preservation of these trees, yet that is the analysis the board needs to apply under the code. Now we'll go to tab 6. What I've done here, I've told you about these two administrative processes that allow relaxed setbacks with a view towards saving the grand trees. So we have 2760, which is cited in the code, and the setbacks applied by the city under the CG for single-family conventional or townhomes is RM24. And you can see with the relaxed setbacks, for example, the front by code is 25, but under this code provision I just discussed, it would allow you to get down to 22.5. So pretty nominal, same with the rear and the side. Then the code also cites 27-156, as I mentioned, and here again, the front is required as 25 feet, and they let you go down to 18.75 feet. So that's how you determine a reasonable reconfiguration. Here again, since the property, the trees are located well within the property, this really has no meaning. Now, if you go to tab 6 again, what I've done here is I've applied 2760, and I've taken the property boundary and showed the relaxed setbacks. So any building could go within this orange line that I'm pointing to. Okay, that's 2760 under the zoning code. And so that line is actually flexed with a view towards saving a tree. Then under 27-156, the second standard in the code, here's trees 28 and 29, the two grands in question, and you can see you could encroach into these orange areas again. So encroaching in those orange areas, that would be considered reasonable reconfiguration, but it really is meaningless in terms of the development of our property and relative to the location of the trees. So we meet the criteria under sections B and C. Tab 7, this is important. This is something you don't have here. And this is standards for approval of grand tree removal by the board. Under this analysis, if shifting buildings does not meet reasonable standards, as you can see on top of the page, a grand tree would be considered hazardous. So if you look at what I just provided you, it says, and I'm surprised you don't have this because it says other construction activities, board approval required. Then it says a grand tree may be rendered hazardous if you meet the criteria. And it says A and C or B and C. So let's look at A and C. So it says it's a hazardous tree if you meet A and C. The applicant says a proposed building that adheres to setbacks without a variance would impact the structure, stability, and root system. Clearly, the answer is yes on that. C, the applicant has demonstrated that there's no other reasonable reconfiguration in terms of buildings and streets. And then most importantly, and this is kind of the key component to this entire discussion, it cites here footnote 5. You can see where I'm pointing. It says the applicant has demonstrated there is no other reasonable reconfiguration of the applicable proposed development components, and it goes down to footnote 5. What does footnote 5 say? It says, what is reasonable reconfiguration? What does it include?
Just a heads up, Mr. Bentley, you're now 1 minute over your time. We'll give you
Okay.
about another minute, and then we'll have to figure out what we're going to do from there, okay?
Okay, guys, I still have my tree guy, and it's only going to take a couple minutes for him, so I'm getting through it. So reasonable reconfiguration includes under 5.2, altering the proposed placement, orientation of any building or altering, okay, provided that, number one, the structure is not adjusted more than allowed by a design exception. We'd have to alter our structure's location more than a design exception, so we meet that test. And number two, there is no change in the number of stories proposed, and the height structure is increased by no more than allowed by design exception to the height of the structure. Number three, the internal flow or function of the structure is not adversely altered by the reconfiguration. So under this analysis here, the trees that would actually be considered hazardous is set forth in the first paragraph. And tab 9 states the staff will provide the board with a recommendation whether the buildings can be reasonably reconfigured. Well, if you look at your staff report, they obviously didn't fulfill their obligation to the board, as the staff never mentioned the term reasonable reconfiguration at all. All it says is the site plan is inconsistent. We submitted alternative plans to the board, and those are under tab 8. And board members, all we did here is staff asked for 2 site plans showing the impact of the trees on reconfiguration, which we did. And clearly you can reconfigure anything. So what we did is we got one scenario, 21 units down to 10.
Mr. Bentley, you're now 2.5 minutes over your time. I'm going to have to stop you. And
Okay.
what we can do is I can ask for a motion from the board for additional time.
Yes, sir.
And we'll see what the board wants to do with that, okay?
Thank you.
Is there a motion, do I have a motion from the board to allow Mr. Bentley an additional 5 minutes? Anyone?
I'll
Mr.
do it,
Farrell?
and then we can, on the opposing side, they can.
Well, they're going to have plenty of time, for sure.
So we give one, we give the other.
Okay, so Mr. Farrell, you want to make a motion for additional 5 minutes in the
Additional 5 minutes
presentation?
to complete the presentation.
Okay.
I'll give him 5 minutes.
Okay,
to the-
is there a second to that? All right.
Okay, so staff.
Wait, hang on.
Wait,
I have a motion, I have a second. Can we have a vote on that, please? All those in favor, say aye. Aye. All right.
Okay,
Proceed.
thank you.
5 minutes, sir.
Great. So,
And that would include your tree expert, so.
okay, I got you. So what we did is submit these 2 examples here, and the staff says we recommend denial because there are 2 alternative site plans showing you could build the project. Certainly going from 21 units down to 10, okay, you can build the project. Here are the trees I'm pointing at. And then the second scenario, alternative plan, okay, it goes from 21 down to 9, over 50%, which is a substantial impact on the development potential along with the economic impact on the client as well. So we have met our burden and demonstrated by substantial competent evidence that reconfiguration under the city's objective criteria I just walked you through would not be reasonable. We'd be losing over half of the project. It doesn't meet that test. I'd also like to point out to you in our binder, it's tab 10, then I'll turn it over to our expert. There are 2 staff reports. There's a staff report dated August 2nd where it says Natural Resources finds the plan consistent with conditions. Then 2 days later, without explanation, there's a second staff report with the same information, okay, provided to staff, and then it says Natural Resources finds the VRB site plan inconsistent. Alternative site plans provided show the 2 Grand Oaks can be preserved with reconfiguration. And even in the staff report you got tonight, notwithstanding all this emphasis on reasonable, and that's what the city council came up for you to make the call on this, they never use the term in their staff report, reconfiguration, or reasonable. Even when they use the term reconfiguration, it says they can be preserved with reconfiguration. And that's not what the code's about. It has to be reasonable, and those criteria are what I walked you through. Now I'd like to bring on Mr. Mark Hughes, a certified arborist approved by the city of Tampa. At least he's on their list. Thanks. Mark? Gotcha.
Mr. Hughes, you have roughly 3 minutes.
Thank you.
Apologies. Mr. Matthews, Mr. Hughes, state your name, your address, and confirm that you've been sworn.
Mark Hughes, 8611 Vivian Bass Way, Odessa, Florida, 33556.
And you've been sworn.
Yes, I've been sworn in.
Thank you.
Okay, so we'll give the quick version on this right here. We have the 2 grants. You know, you've had a number of arborists look at these, a couple independent arborists, some arborists from the city. These ratings have came back on these 2 specific grants that we're asking for a VRB for, anywhere from a C7 to a C9. So bottom line, we're here. They evidently weren't deemed hazardous through the process. We're here, you know, playing ball, going down the right channels to try and get the variance to remove these 2 trees right here, which again, from multiple arborists have been, you know, rated at a C7 to a C9, both trees. These trees, you know, they have some highly compacted root zones from the vehicle traffic and aggregate over the years. That's both of them. They both have a multi-stem structure, you know, which will lead to failures. The highly compacted root zone can have some unforeseen root decline and stress that we have seen in some of the thinning canopy parts through the report, as you will see there. And unforeseen, you know, this is an off-site tree here, but a tree we recently encountered, live tree, green, very, you know, vibrant, vigorous, showing a lot of vitality, but unforeseen root damage, and that tree went down. Okay. Then right here you speak to the multi-stem. This was another live oak. That previous tree was a live oak, same species of the tree we're looking at. This was a live oak right here, showed great vitality, a multi-stem. They're prone to failures right there. So these are both characteristics that both of these grants do have. You have some overextending laterals that lack secondary, scaffold branches that lack secondary laterals, which will make them a little more prone to failure in wind events. You know, if we're filing for the permit on this, we're under 284.2.5. If I was going in and filing a TRE, or a variance for this, and I would be citing this city code right here, you know, under other construction activities. I've done a number of reports to remove trees under this right here, you know, and Mark's read that code right there, A and C. That fulfills that because the construction, while live oak species does have a good tolerance to construction stress and impacts, when you already have the root compaction, the multi-stem trees, one of them has multiple failures in it. They're showing, you know, lack of compartmentalization. This here is a Asterium fungus that is usually around decayed areas. Not a super aggressive fungus, but once it starts colonizing a tree like this, it can lead to some heartwood rot. So again, already declining assets. You know, they have light fixtures. There's an old pulley right here grown up in there.
Mr. Hughes,
Yes.
you're out of time. Can you wrap it up, please?
And it just goes, we'd be removing these trees under the, reasonable reconfiguration. It's unreasonable to keep them, and they would still endure some construction impacts right there. And, further decline this already declining asset. Thank you for your time, everybody.
Thank you very much.
That's mine. What's that?
Kamaria Pettis-Mackel from the City Attorney's Office. Mr. Hughes, I believe you showed some photographs or photo outside of your staff report. Can you ensure that the clerk has those, please?
Yes, I will.
Okay. I'm going to guess that we have some members of the public who would like to speak on this petition this evening.
Sorry. Kamaria Pettis-Mackel from the City Attorney's Office. I do want to approach the board, or I can hand it to Mr. Farrell. The city did receive, I believe, 76 letters in opposition. I do want to pass that to the board.
Okay.
If
So we will acknowledge in the record that we have received these letters and that you're passing them up, and we'll review them during the course of this presentation.
And yes, I don't know.
Yeah, we've received them via email as well, I think.
Yes, those letters are in the seller record.
Okay. Given the volume of people that are here to speak tonight, do you want to put up or show the criteria again? I know that the petitioner went through the criteria that the board needs to adhere to. Do you want to provide that criteria, put it up on the Alamo or something like that, so that anyone who's speaking understands what the criteria that we need to consider is, so that they can direct their comments towards that criteria?
Kamaria Pettis-Mackel from the City Attorney's Office. Ms. Barnes, do you have your staff report?
I mean, certainly, and let me be clear, certainly anyone who wishes to speak, you have 3 minutes to speak, and you're welcome to do so. But in terms of the criteria that we as a board need to adhere to, it's the criteria that Ms. Barnes is putting up here this evening. So to the extent that any of the comments can be directed towards that criteria, that would be most helpful to the board to understand.
Mr. Chair, I've got the criteria here. There's a criteria above and beyond that one sheet of paper that's on page 1.
Well, if you want to put that up as well,
Yeah.
or in addition, that's fine. Look, and just so we're clear, again, no one is constrained to speak about this. They can talk about, if people want to come up and tell us about a tree they climbed when they were a kid, they're welcome to do that. But to the extent that it's useful to us, this criteria is what we are constrained to deal with.
And just for the record, the board's criteria for the removal of 2 grand trees is 27-284-2.5, subsection F, subsection 4, factors A through F.
Okay.
And this code
what we should
section
look
here,
at
which
then.
says the board approval required and lays out the criteria, that's in your backup.
You're covering the entirety of the
Yeah,
one that Ms.
I would
Barnes put
suggest
up
we
there.
look to the other one.
Okay,
There you go.
but tab 7 has the other criteria, Mr.
Okay.
Chair. Thank you.
Thank you. And it's there for everyone. Again, no one is constrained to speak on that. I'm just trying to give some guidance if people want to speak as to what the rules that we have to adhere to are. All right. So if you'd like to speak on this application tonight, why don't we start with 2 lines down the side? Right? Anyone wants to stand up, or do you have designated people who want to speak? I don't know how you all plan to do this. Anyone who wishes to speak on this petition, come on up. We'll take you one at a time. You have 3 minutes each.
Who do you want to send it to?
No, that's not what we're doing. I even thought that was what we're doing.
My name is Patricia Allen. I'd like to donate my time to Carolyn Bennett.
And before each of you speaks, if you would please state your name, your address, and confirm that you've been sworn, please.
My address is 4202 West San Miguel, Tampa 33629, and I have been sworn.
I'm sorry, I didn't catch, I was
Sorry.
handing out something else. You said your name was what?
Patricia Allen.
And you're giving your time to?
Caroline.
Okay.
Okay. Or, yeah, usually don't, but we'll allow it this time. Go ahead, your name, address, and you've been sworn.
Hi, my name is Carol Ann Bennett. My address is 4116 West Santiago Street, Tampa, Florida, and I have been sworn.
We'll give you 6 minutes.
Thank you. The city of Tampa spends a lot of money getting Tampa's tree canopy evaluated every 5 years. The 2016 report found that Tampa's trees had decreased by over 2%. I am sure the 2021 report will show even more loss due to the state law that allows unscrupulous arborists to make money by declaring any tree dangerous. Some people make fun of tree huggers and say we're impractical and we ignore the hard work of a successful city. Well, I say with cold, calculating avarice, if you want a lot of free money, get more trees. If you want to throw money away, cut them down. The 2016 scientific report calculated that Tampa's trees save Tampa about $139 million a year. Therefore, the cost of that 2% tree loss is $2.8 million a year. Every year, think about it. That's almost $3 million of free money we are losing every year. The urban forest provides countless benefits that have a positive impact on human health and welfare. For many benefits, like avoided runoff, trees with more leaf area contribute the most. Oak trees are the top species for leaf area, accounting for 27% of it in the city, despite being only 8% of the population. Tampa has a type 1 young population urban forest. Each of the 4 size classifications should have 25% of our trees in them, but Tampa has 70% of its trees in the small size class. The study specifically cited tree removals due to development as contributing to this imbalance. We cannot afford to lose any of our large trees. Most of the tree's benefits are not achieved until it's mature. If you remove mature oaks, you take away the stormwater buffer for that neighborhood, and it is going to flood. And you have changed the character of that neighborhood forever. Live oaks live for centuries. The people in this room will not live long enough to see the benefits of the oaks we plant today. We must play the long game. We must not be seduced by short-term temptations. An appropriate plan for this site would provide space and aeration for these trees. This has been done many times to preserve grand trees on development projects in Tampa. With a reasonable design and remedial action, these trees will reverse course and get better. Numerous developers have done this. They just need an incentive. If you deny this variance, I am confident they will design a project that preserves the trees and has more than 10 units. If they can't, they should have bought the property with plans to build only 10 units. If they don't like that, then they shouldn't have bought it. If you need to carry a gallon of water, you don't buy a quart container. There are 14 citations in the comp plan that prohibits this variance. You have copies of them. This is competent and substantial evidence. I will just read the highlights, and I'll try to read them quickly. ENV Policy 2.1.3, all development within the 100-year floodplain shall be in strict conformance with applicable development regulations. This property is in the 100-year floodplain, and the tree code is a development regulation. ENV Objective 2.1, development must be compatible with the physical conditions of the land. NE Policy 1.3.5, neighborhood assets such as trees identify the neighborhood and contribute to the well-being of the people who live there, and they must be enhanced. ENV Policy 1.27, protect and enhance the tree canopy. ENV Policy 1.27.2, maintain and expand the urban forest. ENV Policy 1.27.5 and ROS Policy 1.3.3, promote the city's tree ordinance and support tree preservation with minimal impact to the existing site resources. ENV Policy 1.28, maximize the retention, enhancement of the city's mature shade trees for the environmental value and for the contribution to quality of life. ENV Policy 1.28.1, maintain and increase environmentally beneficial plant life. ENV Policy 1.28.2, increase tree cover in areas of vehicular use where the urban heat island effect could be mitigated by trees. ROS Policy 1.1.6, Ensure that open space is a component of private development as it contributes to the quality of life for residents and creates space for the planting of trees that can grow to their mature size and increase the overall tree canopy coverage for the city. ROS Policy 1.3. Mature tree canopy is a vital community and environmental asset that is appreciated and desired by residents in new and established neighborhoods alike. The protection and supplementation of this tree canopy is a necessity to sustain the resource and maintain the environmental benefits, such as cooler temperatures that the mature canopy provides. ROS Policy 1.3.2, retain optimum tree cover in Tampa. LU Policy 9.3.9, ensure high-quality urban design by enhancing distinctive natural characteristics, such as shade trees, to strengthen neighborhood connections and reinforce Tampa's unifying design features. And just in closing, I want to say that this alternative plan that they've submitted reminds me of my children when I told them to do something they didn't want to do and they did a lousy job just to show, oh, I couldn't do it. I think necessity is the mother of invention, and I don't think for one second that they can't save the trees and put in more than 10 units. Thank you.
Next. Name, address, you've been sworn.
My name is Dana Gordon. I'm with Ballast Point Neighborhood Association, and my address is 3019 North Adams Street.
And
Good evening.
And you've been sworn.
Pardon?
We need for the record, you've been sworn.
Oh, I have been sworn.
Thank you.
Also, may I ask for one additional minute?
Talk as quick as you can.
Quick as I can. Okay.
The woman in the back.
Excellent.
Go ahead.
She's willing to donate her minutes, if that's okay.
We're going to spend 45 seconds just talking
Caroline D.
Can you say it on the microphone?
Caroline D., 3301 North San Miguel Street, Tampa. And I've been sworn.
Maria Pettis-Malco from the City Attorney's Office. Are you donating your time to this?
Yes.
Okay.
We just, for the record, we don't typically allow donations of time, but we're giving a little bit of excess leeway because of the number of people we have here. We gave the petitioners some additional leeway, so we're giving it to you, but please proceed.
We appreciate that. Thank you so much. Mature trees provide many benefits to society that often go unrecognized and undervalued, which historically leads to poor tree resource management decisions. One of the main goals of the city's long-term T3 mission is sustainability and resilience. One of those core values is, quote, ensure decisions consider life cycle environmental impacts, end quote. Ultimately, protecting our mature old-growth trees is an essential component of resiliency. I had these passed out to you, so I will also place it up here. I'm not sure how to use this. There we go. So obviously I'm not going to read all of this to you, but some of the things that I wanted to call out, this is all information that was pulled directly from the United States Department of Agriculture website. And some of the data shows the very documented and proven benefits of having a tree canopy. So some of those are, under number 1, absorbing airborne particulate matter and producing oxygen. Number 2 is storing carbon. Number 3 is mitigating the urban heat island effect. Number 4 is providing modest wind shelter. Number 5 is avoided runoff and flood alleviation, which is very directly related to reducing the annual red tide blooms, which is obviously a major concern for us in the Tampa Bay area. Number 6 is providing character and local distinctiveness to the neighborhood. Number 7 is encouraging activity and recreation. Number 8 is protection for threatened species. And number 9 is reducing crime. Number 10 is all the secondary ecological values. That goes on and on and on. All of these outcomes provide proven economic benefits, such as increasing overall land and property values, reducing time on market for developers, reducing power bills for the homeowners, and reducing expenditures in stormwater infrastructure and flood defenses for the city overall. On a different note, size really does matter. Developers continually use the very convenient assertion that replacing old-growth trees with a higher number of smaller replacement trees is an adequate substitution. However, research proves otherwise. According to ARUP, a global engineering design firm, the annual ecological benefit of a large established tree is 92% greater than planting a smaller one in its place. The next item I'd like to focus on is the comp plans for both the City of Tampa and the Ballast Point neighborhood. The City of Tampa comp plan places much more importance on the character of a neighborhood. The city continues to emphasize its value in both the overall comp plan and the municipal code in several places. For the Ballast Point comp plan, one of our many comprehensive goals is to maintain and enhance an excellent quality of life in the Ballast Point neighborhood, characterized by a calm and pastoral ambiance and supported by the following. Number 1, a low-density, low-rise residential land use. Number 2 is a significant canopy of trees. And number 3 is environmentally sustainable conditions and activities. If the developer would like to see an example of a well-planned multifamily complex that meets this criteria, I encourage them to visit the Las Palmas Townhomes located at 3335 Los Campos Place, which is only 4 blocks west of the Kojaks property. Both adjacent neighbors and residents agree that they provide multiple residents while still maintaining the old-growth trees, and they appreciate that protection. Lastly, if it hasn't already been said, this property, having a 10-foot elevation, is officially designated by FEMA as a floodplain, and according to the City of Tampa Comp Plan Environmental Policy 2.1.3, which Carol Ann also mentioned, quote, all development within the 100-year floodplain shall be in strict conformance with applicable development regulations, end quote. Taking all of this into consideration, I ask that you please vote with the best interests of the community's well-being in mind, stay true to both the city comp plan and the Ballast Point comp plan, and do not allow this developer to remove our valuable and irreplaceable old-growth trees. Thank you so much.
Thank you. Next.
So, she's not allowed to donate her time, are you saying? I'll try to get through it.
Go ahead. If you
Otherwise,
need
she's
a
going
little...
to have to read half of it, and she won't understand my scribble.
That's fine. Go
Okay,
ahead.
thanks. So, do you want to give your name and time?
My name is Donna Date Smith, 2403 West Chicago Avenue, Tampa, 33629, and I've been sworn.
Hi, my name is Pamela Jackson Haney. I live at 3014 West Harborview Avenue, Tampa, Florida, 33611, and I have been sworn in. I've lived in South Tampa for 27 years, and I'm here to ask you to save the grand trees on this very unique and beautiful property that's reminiscent of a scene out of A Land Remembered, if you read that book. The developer acquired this property knowing full well there were majestic grand trees on this property and that they were protected by law, and yet the developer, citing hardships, seeks to destroy them. The seemingly insignificant procedure of getting rid of a couple more grand trees in the name of progress is no longer insignificant and needs to stop right here tonight by redesigning a sustainable plan. Now more than ever, we need to save these grand trees to benefit our environment. Surprisingly, these grand trees now only make up less than 1% of our city's tree canopy. Citing from the UF-IFAS, a valuable resource, urban forest ecosystems provide a variety of economic and environmental benefits, including shading homes to create energy savings, intercepting rain to reduce stormwater, improving air quality by filtering pollutants, and sequestering carbon to offset emissions associated with climate change. I thought this was interesting. Many urban forest benefits are influenced by the combined surface area of all the leaves in a single tree's canopy. Researchers used leaf area measurements to estimate the benefits provided by individual trees in an urban forest. Digging into this issue, many of us have learned that the present approach of approving removal of trees before considering other critical development and environmental issues, such as flooding, is wrong and backwards. Tampa's trees do not have a chance if this continues. The federal and city codes that are in place are there to be followed for good reasons. This property can be developed and the development redesigned in a manner to both conform with applicable rules and be profitable for the developer. The developer has the tools to do this. The several codes were already mentioned. I would like to reiterate Environmental Objective 2.1, Environmental Policy 2.1.3 regarding the 100-year floodplain, Thus, I believe no variance should be granted. CM Objective 1.3 and Policy 1.3.8. I won't read those again for obvious reasons. The city arborist evaluated the grand live oaks and rated them as being in good condition and stated they would not be permitted for removal. She said they could remove many other trees on the property, but not those two grand trees. That should be enough, but since it isn't, I believe the VRB now has enough information to deny this application, or at least to request a redesign from the developer. As you know, the developer hired 2 arborists. One of the reports is quite biased, with the arborist giving opinions on the planning aspects of the site as opposed to how to preserve the trees, with statements like, due to impending construction and no reasonable reconfiguration or reasonable design, and also suggesting no mitigation is required. That report should be completely discounted. The developer's second arborist calls these grand trees moderate risk as opposed to high risk, which means they can be salvaged with proper care. This is good news. This will require a revised plan by the developer that provides needed space and remedial action for more aeration to assist with the roots, the compacted roots. And this has been done as shown before many different times. The requirement for this lot is to save 50% of the trees. I noticed the developer removed that request for this variance, so I won't get into that. But fortunately, he has agreed to save the grand tree in the back southeast corner. But I'm curious about what code enforcement is in place making sure this becomes a reality and that the tree is taken care of and nursed back to optimal health so it can be counted as one of the trees the developer is saving. The developer's plan needs to be modified to ensure this, otherwise it's just an empty promise. As for the other trees the developer says they are keeping, they're on the sidewalks. Should these even be counted in their favor? I don't think so. Again, this calls for a redesign. In closing, there are no hardships here. The law clearly states that a practical difficulty shall not justify a variance. A rare opportunity is before you and the developer. I'm asking that you save these trees and call for a reasonable redesign of the project and an arborist plan to address bringing these trees back to full health. Go back to the drawing board. The developer will still make a hefty profit, and the community will be better off for their efforts. Personally, the alternate plan with 10 townhomes looks great to me. Maybe make them bigger homes in a lovely tree-covered setting with appropriate green space as our code demands. We all know they will sell for a lot of money and could be a shining example to all developers on how to build thoughtfully instead of carelessly. Thank you.
All right. Anyone else like to speak on this petition?
Good evening. I'm Sean McGowan, 4811 Bayshore Boulevard. And yes, I've been sworn in.
Thank you.
Thank you. I'm the president and resident at 4811 Bayshore Boulevard. Though our complaint here with the PCG group is not directly related to the tree, we're asking you to consider allowing this construction group to further damage the areas around our community. Currently, the PCG group is building the shore house directly across the street from Kodak. During their building, they have violated numerous permits and fined by the city. The largest damage that they've done, they flooded out the entire community, Building 3 of Bayshore Carriage Homes. We have pictures here of our community where the backyards are 4 inches of water. We had to put sandbags down to keep the water from encroaching into our homes. This was during the time of Hurricane Ida. We called in city officials in an emergency on a Friday, and we do have a list of all of those officials that showed up on site to ensure that they did something not to totally flood out our entire homes. However, our yards were totally flooded out. In addition, one of the violations of a permit was they were to build about 5 to 6 feet away from us. They violated that permit and built 3 feet in. They are directly sitting on top of us, to the point it looks as if their building is about to tilt over. They've used our property as barriers. They've put porta potties along our entire backyard, and we constantly call the city complaining about them violating noise ordinance. in addition to their supplies flying over into our backyard. We've sustained $30,000 in damages. They uprooted the entire artificial turf in all of our backyards on Bayshore Carriage Homes Building 3.
Their remediation initially,
Hold on. Before you talk, name, address, confirm that you've been sworn, please.
Eric Mortimer, 4811 Bayshore Boulevard, Suite 305, and I have been sworn in.
Okay, you have 3 minutes. Go ahead.
Thank you. Initially, when they brought in all the fill, it was approximately 3 feet of dirt they brought into their property. This drastically changed the natural waterways, and their engineering plans did zero to address the fact that all this dirt water is going to flow into our backyards, which it did. When we complained about it, their initial action they took was they used a backhoe to basically move dirt against our fence. And we have these non-load-bearing fences that are now bulging into our backyard from all the dirt they pushed up against it, trying to create a dirt wall to keep water from going through the fence. Well, that just turned into mud. So our entire backyards, the turf is destroyed. You can't get the mud out. I mean, the fences bleed mud when it rains now. The turf is destroyed, and they have built a wall now, but there's damages that we should not have to absorb ourselves due to their lack of oversight, lack of planning, and lack of just really caring.
And in their violation of their permit... Okay.
Before you speak, name, address, confirm that you've been sworn.
Oh, each time.
Each time.
Thank you.
And just for clarity's sake, y'all, you have your time. You can speak your piece. You can do whatever you need to do. We can only consider evidence as to the petition before us.
Yes.
All right? So you had about a minute left on your time. If you'd like to use it, go ahead.
Thank you. Sean McGowan, 4811 Bayshore Boulevard. With the building so close to us and violating that permit, the company even emailed us requesting that they set up scaffolds within our backyard so that they are able to finish the stucco on their building. So there was a total disregard and menace to society that this group has done to us. We've emailed them constantly requesting that they build that drainage system in place so that we will not sustain any further flooding. They started the building of that wall but have not completed it. They've dug a trench along our back fence that will probably most likely collapse the dirt that's under it because they're using it as a barrier. So though we're not directly mentioning the trees here, our point is that this construction group has been a total disaster to our community over on Bayshore Carriage Homes as well as the Gandy Boulevard area.
Okay, thank you. Next. Name, address, confirm you've been sworn.
Pat Higgins, 2807 West Marlin, Tampa, Florida, 33611. My property backs up to the Kojak's property. I can walk out the door.
I'm sorry, before you continue, can you just confirm you've been sworn? I apologize.
What?
Can you just confirm you've been sworn in, please?
Oh, I have, yes.
Thank you.
I've been sworn in. So of all the people in this room, I'm the closest to this development. And I respect you people, but I think this organization's already started to build or do something down there because for the last 2 weeks, they've had trucks and all kinds of equipment going on there. Because I have my coffee in my kitchen, I can look out and see them. What I'm worried about is the flooding. She said it all there, so I might as well not go into it. But I'm not real happy about the construction, but whatever. That's all I have to say. So I hope you guys will really think about it. I'm sure that when they cut down the trees, it's going to hurt me, and I don't like the idea of workers there for 2 years without a fence. I am a widow. My husband was a builder in this town for 40 years. And when he took a tree out, he planted another. He had to. So that's all I have to say. Thank you.
Is there anyone else here to speak about this petition? All right, come on forward. Name, address, and please confirm that you've been sworn in.
Absolutely. My name's Stephanie Pointer. I live at 7709 Landcare Lane, Tampa, Florida, 33616. I really came down here to donate minutes this evening, but the longer I sat here and the more I heard stuff, I was like, wow. Can I get this on, can we get this big enough that you guys can see it? Because I'd like to show you where this particular lot was locked by the city of Tampa by the folks who said, you can't do any tree work on this on June the 3rd. And what it specifically said, what they failed to tell anybody on the variance board is that in May, they did a significant amount of tree work. And they very specifically, the city staff very specifically said, you are not to touch these trees. So how is it in a 3-month period, 100-year-old trees have went from being sustainable and protected by city staff to this gentleman saying, oh, they'll fall into pieces. It doesn't make any sense to me. What makes sense to me here is they asked Mom in May if they could cut these trees down, and they were told no. Seems like we're here 4 months later, and they're asking Dad if they can do the same thing that Mom told them no for. That doesn't make any sense to me. The petitioner has brought up repeatedly that city staff doesn't understand, that city staff is confused. If city staff is confused, then do the neighbors understand this? I would say no. I would say that they weren't confused when they got here, but this gentleman's laid out a whole bunch of information that seems quite confusing now. And this should be continued if it's not denied. Have a good evening.
All right, is there anyone else who'd like to speak on this petition? All right, hearing none, I will open it up for board questions. Does anyone on the board have any questions for the petitioner or for any of the public commentators? Any questions from the board? Mr. Pastor.
Mr. Bentley.
Yes, sir.
Can you speak a little bit about the removal of the request to reduce from 50% down to 13%? Because you said you withdrew it, which I understand, but did the plan change to make that withdrawal, or what happened?
Yeah, it was a combination of things. Actually, after meeting with staff, I had 2 arborist opinions. What we did is we made adjustments to the project and shifted it, I'll just say fundamentally eastward, and did some minor shifting. So the original request was 13%. Then it got up to 47%. If I would have presented it tonight, the reason I didn't is because we can meet the 50%. Okay. But that was after some hard analysis here. And actually a greater understanding of the code, which you can see based on my kind of chaotic presentation. The only trees that are considered for retainage in terms of the 50% are trees that are classified either A or B. I think you go A, B, C, or D by the city. And a lot of those trees out there are Cs. And also 7 trees had been removed early on because, and I've got the permit here and the characterization, because they were hazardous. There were 7 of those. So, but we're all good on the 50%.
Okay, so then my next question is, you keep pressing on the reasonable reconfiguration, and you mentioned how the city hasn't used that term, and then they did, et cetera. And when we heard from Natural Resources speak, he mentioned that there is reasonable reconfiguration that can be had, but reasonable, of course, is the term in question. So what would you say to the question of what makes it reasonable? Why is the reconfiguration that you showed the 10 and the 9 unit, why are those not reasonable in your mind? Because we don't have a right to maximize necessarily, right? We're looking for a reasonable reconfiguration. So what would you say is reasonable?
Okay, just to back up a second, what the staff mentioned to you was the petitioner had filed 2 alternative site plans, which is not even required by your code, but they asked, we supplied that, okay, to show that we would stay out of the protective radius and shift the project entirely over. Here again, as I mentioned, I think at the commencement of my presentation, the comp plan would allow 37 units on the subject property. The proposed development is 21. With these alternative plans, we're simply just an exercise to show that the relief that would be granted, your code says reasonable reconfiguration is if you can achieve saving the grand trees by the amount allowed either through a design exception or under 27-156. And I showed you those code sections. And those relax the setbacks, okay? So by definition, neither one of those would have helped save the trees because of the location of the trees being more in the center of the property. With respect to what's reasonable, the code criteria that was up here actually under B, it says whether the proposed building can be reasonably reconfigured as defined in 24.2.5, which is design exception under 2760. And I showed you under tab 8 a site plan showing how much relief we could get. So just applying the code right there, it says that's unreasonable because we can't achieve saving the trees under 2760.
Yeah, I don't believe that's true though. That's kind of what I'm asking. You're implying that reasonable reconfiguration requires that it be achieved through the slight reduction in setbacks. I think that that's a leap you're making. It doesn't require that that be the remedy. It says that's an optional remedy.
No.
If that can help resolve the issue, then you may get these reduction in setbacks.
Well,
It says
actually,
that the reasonable reconfiguration must include the recommendation by the Natural Resources Coordinator, and it doesn't limit the extent of reconfiguration to that provision.
okay, well, the Natural Resources Coordinator never mentioned what's reasonable. He just said the petitioner filed 2 alternative plans. But when you get to tab 7, it says activity impacts board approval required. It says a grand tree may be rendered hazardous if A or B exists, and one is A, proposed building footprint would impact the structural stability, or C, the applicant has demonstrated there's no other reasonable reconfiguration of the applicable proposed development, citing footnote 5, and says reasonable reconfiguration includes altering the placement, orientation, or height of any building, provided that the structure is not adjusted more than allowed by a design exception as provided in section 2760.
Right,
Then
not more
that's-
than, but
Okay.
certainly less than.
Then that's not reasonable, or if the internal flow or function. So City Council came up with these definitions here and some guidance for us, the property owner, developer, and this board to determine what's reasonable, because we will never agree on what's reasonable. You asked me out of the box, what do you think is reasonable, going down from 21 to 10 or 15? Obviously, to the client, based on the price, the unit value of the property,
Right.
21 is reasonable. He could have gone higher and really packed that property and gone for the 37 if he
Right.
would have rezoned it to PD.
That's my point. So you reduced from 37 to 21, that's a reduction of
Correct.
16. You consider that reasonable?
Yes, sir.
So one of your alternate site plans reduces from 21 to 10, that's a reduction of 11. That's less than
That's
16.
57%, I think.
So why is that not reasonable? My point is to pitch it to us that not using the design exception means that it's not reasonable, I think is a distortion of what the code says, because you can always do less than. The design exception is to do more than. And it says you cannot do more than, which is what you pointed out. My point is you can do less than.
But you have.
So what's reasonable? That's
No, I understand.
the question
But-
at hand.
But here on the consideration by the board, that section 4 that was on the overhead, and it's in your staff report, there's 1, 2, 3, 4, there's 5 criteria, and 2 of them deal with 27 2360 and one 2756. That if you can't achieve saving the tree, okay, by the relaxation of the setbacks, we'll call it, then that's unreasonable. You've got 2 of the 5 criteria. The first one, what we're talking about is the impact the proposed building says the board shall consider on the trees based on a surveyor drawing. We've met that. B, whether proposed building can reasonably be reconfigured pursuant to a design exception. The answer is no. C, whether you can, same thing with relaxation of the setbacks under 27-156. The answer is no. And D, whether alternative construction methods can be utilized to preserve the grand trees requested for removal up to the critical zone. I'll have Mark Hughes
All right.
testify
Well,
that they can't.
Clearly, we're talking in circles.
Yeah.
And we disagree, so I will
Okay.
move along to anybody else that has questions.
Okay, thank you.
Fire away, Mr. Farrell.
For staff, please. No. Oh. Yeah. And first of all, please, I live in a city in South Tampa with a 77-inch oak tree, so I'm a favor. My question is, obviously, it's a question of being reasonable. Is a comp plan, which is when you purchase a property
You
based
asking
on
me or asking her?
Excuse me. My question is what the client outlined in red when he went through the setback requirements and talked about the reasonable easing of setbacks, is that line that he drew around the property, is that not in essence the same lines that we drive in concept, that we draw when we look for variances? We have a zone when we do single families and we look at a property, and if there's a red line zone, that if you are within that zone, you have clearly shown that you cannot reasonably reconfigure the house and meet any kind of required setbacks whatsoever. So my question is, did they in fact show that that is in fact the allowable building envelope on this property?
Anastasia Barnes. Unfortunately, I didn't receive this packet, and I couldn't see. My eyesight's not that great to see it. However, Mr. Bentley has provided it currently. When I was listening to the presentation, it was my understanding that's in regards to reasonable reconfiguration in accordance to the additional grand tree removal regarding a, unfortunately, I haven't had time to evaluate this. You know, I saw the presentation, but I can't answer your question definitively. I'm very sorry.
One other question, how is it that a comp plan allows for an amount of units? Is the overall
Sure.
comp plan?
Sure.
And a developer comes in, plays by the rules, declassifies that down by 40%.
Mhm.
What reasonable assurance do people have coming to this city that they buy property based on a zoning
Right.
ability to do something, and then find out once they bought it,
Mhm.
they're not allowed to do that? Where does that,
So obviously,
reconcile?
you're correct. So you have your zoning and your future land use, right? So your amount of dwelling units as well as setbacks. So it's dependent upon each property when, and that's up to the applicant and the designer to do that, do their due diligence to make sure that whatever proposed development that they're requesting can fit on that specific property, including taking in accountability any natural elements of the project, as well as, so it isn't always the highest number of density or units that is allowed per the comprehensive plan.
right?
That isn't always the outcome. So that's up to the developer to make sure that they do their due diligence, to make sure that what they're proposing will fit on and adhere to all applicable regulations.
Last question for you. Could you tell us why there is one report that says it's good and one report why it says it's not?
Hello, Stephen Eister with Natural Resources.
Hold on a second, your microphone just was turned off. Yes.
Hello, this is Stephen Eister with Natural Resources again. So when I went out and evaluated the trees today, I evaluated them as a empty restaurant. If you look at our criteria and you look under target, it is no longer a high traffic, always traffic area. This is now a vacant site that they are storing materials on, but it is vacant, low traffic, lower target, lower risk. If you look at Dave's initial report, it says the trees are moderate, which is also same with my C7 rating and C6 rating for the tree that's off in the back of the property.
I'm still not, it's okay, it's not gonna get answered, but
He's
that
asking,
clearly is no reason why, no explanation as to why you go out and approve a project. Nothing changed from the initial report versus the second report except 4 days.
So
how is it that changed?
So you're talking about the staff report?
your staff report.
The
Yes.
consistent with inconsistent?
Yes,
And
that you
then-
see one staff report that says
Yeah.
it's consistent, and then you say one that's not inconsistent.
So from how I initially understood the process, I'm new, people make mistakes. The inconsistencies that were on the second report are the same comments. They're not new. We changed it from consistent with conditions after reviewing them with Brian, who's the senior forester. He said, Stephen, these are not really conditions of the project, they're inconsistencies. So we updated it.
Okay.
I have a quick question for the developer. Mr. Bentley, I'm sorry. On tab 4,
Yep.
if you could just turn that so that those dark, yeah, things are, no, you had it, yeah. What are those dark buildings up at the top and why are they different? Because when looking at the site plan, it looks like those are over the boundaries of buildable space.
Now, what they're doing, what we've done is the city wanted a reorientation of the buildings adjacent to Gandy to be more frontage. They were oriented the other way internally. So when we submitted the revised plan to the zoning department, they want us to identify those units. So the front doors of these 3 units are facing Gandy, whereas before they were internal like the others.
Okay, but they are within the setback.
Yes, ma'am.
Okay, thank you.
Kamaria Pettis-Mackel from the City Attorney's Office. Can staff just explain what applications are pending regarding this property?
Anastasia Barnes. I believe I briefly went over the previous, in my initial report for this case, the current in-process applications, but I will specifically outline them. There is a special use 2151, as well as a design exception 21203, regarding the single-family, the proposed project for the single-family attached dwellings. So that's in your staff report as well, so they should be outlined there. But just to further specify.
You know, just to comment on that is, we have these other applications pending. One thing is we're not rezoning the property, and so it's a kind of thing, we can't go.
I don't, nobody had asked a question.
Okay,
to
I'm
you.
just letting you know, we can't go forward with the other application, so we
Okay.
resolve this issue.
All that's before us tonight is a removal of a 40-inch and a 42-inch grand tree.
No, that was my concern, to bring in this extraneous information here, so thank you.
Okay, that's all that's before us, is the removal of the 2 grand trees. I think we were just being told what else is going on, but all that's before us is those that issue. Ms., quick question for legal. You there? Are these 2 grand trees, this is one petition, or are they splittable?
No, this is one variance request regarding the 2 grand trees.
Right,
Right.
okay. But
Sorry, you saying, can you,
I don't have any intent to do that. I just want to make sure, I just want to understand how we proceed on the 40 and the 42-inch. It's one.
it's one request.
Okay.
And the trees numbers specifically are number 28 and 29 according to the application that was submitted.
Okay, well, it's per the site plan, understood.
Right.
Okay. Are there any other questions from the board for anyone?
Yeah, I have a quick question for Mr. Bentley.
Okay. Go ahead. Did you-
So if you turn to tab 8, that has the 2 alternative site plans on it. And my question is, can you give us a little bit of background as to what went into planning, to developing these site plans? Are these the maximum number of units that you can put on this property while saving the trees?
Here's
Thought process.
Here's the analysis. We wanted to keep the unit size and quality the same as the 21, okay? So what we had our engineers and our architects, Kurtz Gaines, we told them to lay out, to respect the trees and the radii of the 2, 28 and 29, and lay out a project that comports with city code, okay? And this is the 2 alternatives that they came up with. And then also, we wanted to, if you look in the southeast corner here, I think one of the neighbors had mentioned that's tree 52. We also said, while you're doing that, please protect, let's try and, because this was targeted before number 52. So we eliminated any unit there and any driveway and things like that. So that's kind of the genesis of how we ended up with this. And to be quite honest, the staff just generally says, give us 2 alternative site plans, okay, to demonstrate that there's no reasonable reconfiguration. And that's the way we read the code, and that's what we did. Thank you.
Okay, and so there's a red line, like hashed, kind of like dotted line around the edge. That's the current setbacks? That's not the relaxed setbacks?
Yeah, those are the current setbacks.
Okay.
Thanks.
Mr. Murphy, you have a question?
I did. It was kind of in the same line. So you were asked to create 2 additional site plans, but it sounds to me like these are not your 2 best additional site plans. Is there a possibility of a better layout
Wait
that
a
could be
second.
generated?
Why don't we do this? This is Mr. Michael Mintzberg. He's the principal with the ownership.
Okay.
Are you sworn in, Mike?
Yeah, Michael Mintzberg, the developer, 1925 East 6th Avenue, Tampa, Florida. I've been sworn in.
Yeah, so there's a lot that goes into these site plans beyond just, hey, where can I put a unit? You have to have trash circulation, emergency vehicle circulation, dumpster enclosures. And so, these are, and with following in those setbacks, these are, they gave us one and we asked them to do another one. And these are, substantially good site plans that can be done. We would have to change our unit sizes to get more units in there and respect the trees and be able to meet all of those other requirements that the city requires.
Did that answer your question?
Oh, yeah, that'll do for now.
Okay. All right, last call. Any other board questions? All right. Seeing none, I'm going to open it up to the petitioner. You have 3 minutes for rebuttal.
Just a couple things is the criteria that you were provided, consideration for the board, and I went over these briefly in response to Mr. Pastor's discussion. A, it says, the board shall consider the impact of the proposed building structure on the impact of the trees by a survey or drawing. That's occurred. B, whether the proposed building structures can be reasonably reconfigured as defined in 284, et cetera, which is a 2760 design exception, and they cannot be reasonably reconfigured. Same question essentially. C, whether reduction for primary buildings in section 27156, and here again in tab 8, I gave you the analysis for both of these code sections to show the reduction in setback. So there couldn't be a reasonable reconfiguration under C. D, whether alternative construction methods can be utilized to preserve the grand trees requested for removal. Mark, state your name again and just briefly.
Mark Hughes, been sworn in. Yeah, so when the alternative construction methods can be utilized to preserve the grand trees requested for removal up to the critical root zone there, under the original site plan, I mean, there is no preservation. Under the, alternative site plans there, they do have maximum use, pretty much staying out of the tree protection zone. If you added any more units into those alternative site plans, you are going to be breaching the tree protection zone. And when you breach the tree protection zone, this is what you get. Those are some mitigation trees, but this is what you get here. You get trees that are just not sustainable over time. Breached by the house, breached by the driveway. So the alternative plan.
Sorry. No. Okay. What's your conclusion?
So the alternative plans are the maximum amount of units, because if you put any more units in those alternative plans, you are breaching the tree protection zones and therefore ending up with trees like that, they just dissipate out and decline, stress out over time. And that would be it.
Okay, thanks. So this is a legal variance process that was set up for this particular type of situation with objective criteria, and obviously it's not a popularity contest, because I don't think anyone who wants to remove a tree would ever win such a contest. We've met our burden and demonstrated by substantial competent evidence that any reconfiguration under the city's objective criteria would not be reasonable reconfiguration. The trees are not in good health and are in a state of decline. Depending on the opinion, we have two opinions on that. The trees meet the definition of hazardous as we discussed under table 27284.2.5. The staff failed to meet its burden to demonstrate reconfiguration was reasonable. It never used such a term, but simply said two alternative plans we prepared show impacts of the trees, and the project could be reconfigured. Tab 7 defines what reasonable reconfiguration is for purposes of the board's analysis, and I won't go through that again, but we meet the test there.
Are you wrapping up, Mr. Bentley?
So that's it, essentially. We think we've met our burden, and we sincerely appreciate all your time and consideration tonight. Thank you.
Thank you. All right, with that, I will close the public hearing and open it up for a board motion or discussion.
Kamaria Pettis-Mackel from the City Attorney's Office. When the board is drafting or discussing a motion, whether approved to deny, the site plan that the applicant has showed as the desired site plan as depicted in tab 4 of their binder, this has not been approved by the city for the design regarding a design exception. So if there is any consideration or a board member drafting or thinking about proposing a motion to approve the removal of the two grand trees as depicted in the site plan, the desired site plan, which is in tab 4, this design exception, this site plan is not approved yet with the city, and it's pending approval. And I'd ask that to be as a condition of any approval. And it's specifically trees number 28 and 29 only that are being asked to be removed in this request.
Okay, how would you, for discussion purposes, how would you place that condition so that we understand what you're asking for?
So in your motion helper, you could just.
Yeah, I know, with conditions, the
Right.
condition, you're
Being-
suggesting the condition being that that they would have to
That the desired
receive?
site plan in the design exception be approved.
Okay, all right. So noted, thank you. All right, back to the question of, is there a motion, from the board, would someone like to make a motion or at least get the discussion started?
I can make a motion, we'll see how it goes. I move that variance request for case VRB 2197 for the property located at 2808 West Gandy Boulevard for the removal of 2 grand trees be denied due to the failure of the petitioner to meet the burden of proof with regard to the 6 factors for determining reasonable use as set forth in section 27-28425F4 of the city code for granting tree removal. Specifically that while 2 alternative site plans were provided, the question of reasonable reconfiguration has not been answered, and I don't believe that that burden has been met.
I'll second that.
We have a motion to deny by Mr. Pastor, seconded by Ms. Hurtak. All those in favor, say aye.
Aye.
All those opposed? All right, motion to deny passes 4-3.
Those are not. Yeah. Okay, well, those are. Oh, okay. Thank you.
We're still in a meeting, excuse me. We're still in a meeting.
I don't think this, I think this is not working. Just give it. Yeah, I'm gonna.
Moving on, next case. We ready? No, not ready. No, I don't want to take a break. I'd like to just get this done. It's late enough for all the people who are still on the agenda, so. Yeah.
Yeah, actually, that's a, I. Yes, swear them in and this is not them. Are these all the applications? It's just this gentleman right here? Can you have some all the comments so that we can swear them in and get this, get it moving?
You ready?
Yes, are we waiting for people to come upstairs?
Yes.
Yeah.
Okay.
You have one applicant right there, and the next person's right there.
Can everyone please rise and raise your right hand? Do you solemnly swear or affirm that the testimony that you're about to give today is the truth and nothing but the truth? Yes. Thank you. You may have a seat.
All right, Ms. Barnes.
Anastasia Barnes. The next case before you is VRB 21104. The application, or the location is 4415 West San Rafael Street. The property zone RS75. The variance requested is to reduce the front yard setback from 5 feet to 0 feet to park a boat on a trailer. And the request to increase the allowable height for the craft from 10 feet to 11 feet, and from the length from the allowable 26 feet to 32 feet. I apologize, this projection. Specifically, the section of the code is 27.283.11 A5B1 and B5. There is a current code violation, 212247, associated with this request, and the board shall base their decision on the hardship criteria responses provided for section 2780. And just to go through the packet really quick. Here's the aerial of the subject property, as well as the surrounding zoning, residential in nature, and RS75. And this was the submitted site plan associated with this request. And there were some pictures in the PowerPoint, but currently we do not have access to that. So perhaps the applicant can provide it, and I'm available for any questions you might have.
All right, applicant, why don't you come on up? State your name, your address, confirm that you've been sworn, and then you have 10 minutes.
Good evening. My name is Eric Lowney. I reside at 4415 West San Rafael Street, Tampa, Florida 33629. I have been sworn. I do have some pictures, but I guess I'll go through the hardship criteria first, and then I'll pull the pictures out as we go through. So yeah, basically I have a quarter-acre lot almost here in South Tampa. We bought an oversized lot because I previously had a boat. It's a large boat. It's 28 feet in length. The code takes the measurement from the hitch of the trailer all the way to the prop of the engines, so that's why I need 32. That includes the trailer. So the house that we bought, it's set back on the property, and the property is somewhat narrow, which I don't know if you can go back to the overview that you had. Is it here? Yeah, right here. So you can see the property is somewhat narrow and long, and that's exacerbated by the fact that there was an addition done on the east side of the property, so my side yards are only about 8 feet wide. If I didn't have that addition, I would be able to get the boat through and into the side or the backyard, but with the addition there, it's a one-car garage, it also has our laundry in it, I'm not able to do so. I also have a picture of the front facade of the home. These are all in Acela too, but so I just tried to draw basically a line, from that, basically the front facade of that garage, and just do a straight line across so you could see our front facade is actually set further back than any of the homes on the street. Which is part of the reason why I think the property is unique. if, I'll do these pictures too while I'm already on this screen here. So I took a picture from that's facing west on the street. And then here is an image facing east. So basically just showing you how the boat is positioned. There's some other pictures in the cellar, but I think that probably does a good job showing you. Okay, so the only way that I can come into code if I don't get the variance is I can remove that addition. So I got a quote to get the garage addition removed so that I can then push the boat back into that yard. My request for the variances for all three variances is so that I do not have to take that down. We like having the garage. We do put a vehicle in there. Like I said, it does have our laundry. It also is where the main electrical comes in, so our main circuit fuse box is in there, and we have HVAC that's routed through the attic. So all of that would have to be rerouted. The criteria in the vehicle parking section 27283-11, so I believe the intent of this order is solely focused on the safety concerns. So there are subsection 5B, and then there's 1 through 5. The variance review board is able to grant variances on everything except for the number 2. So that's 5B2, where no vehicle can be parked in a location for any other cause of the site obstruction to any pedestrian or operator, any vehicle by impeding obstruction of visibility of oncoming traffic or visibility of lawfully placed traffic control device. So I tried to take the pictures to show that there's no visibility impediment of where the boat is positioned. I think that the intent of the order is the city wants you to park in the side or the rear if you are able to. I unfortunately am not able to. The home is purchased this way. We just bought the home in April of this year. Like I said, I already owned the boat and brought it to the house. There was a code officer that came and told me that there was a limit on length of boat, which I did not know that. So that's what brings me here today. And then the variance is in harmony with and serves general intent and purpose with the chapter. So I just took this red line on the outside is Sunset Park. The yellow square here is the streets that are directly adjacent to my home. So I just wanted to show you the composition of the neighborhood. These are 7 other RVs, crafts, trailers, which are all mentioned in the same subsection of the code that are already in existence, similar to how I want to park it. I did not take pictures of anything that was behind the front facade or anything like that. So just quickly run through these. So boat in the driveway similar to mine. Another boat that's also tall in the driveway similar to mine. This boat is kind of in like a private drive. There's an RV. Another RV. There's a trailer. And then this is a boat that's parked on the side of the home, but this side street here, the boat's fully visible from this street. So I just want to provide some context for the what the neighborhood kind of composition is. So allowing the variance would result in substantial justice being done considering the public benefits and the hardship that I would incur if the variance is not approved. I would pull the garage down. In the meantime, I'm going to have to put the boat somewhere. While the boat is stored, I have to adhere to the 24-hour rule. That's in this same code, so that's in A2. So I can bring the boat to the house to clean it, load it, and unload it, but I have a 24-hour clock, and I just feel like that's going to be a burden for me to prove when did the boat arrive, when is the boat leaving. If a code enforcement officer came out, how do I show them when I parked the boat? And, oh yeah, the last thing, I'm sorry. I have letter of support from my 4 immediate neighbors. Sorry. So this is from the homes. that are directly to my east and west, and then the 2 homes across the street to the south. So they're going to be the homes that are the most affected by the boat because it's in front of the home on the south side. So this concludes my presentation.
Thank you very much. Is there anyone in the audience who wishes to speak on this petition? Seeing none, we'll open it up for board discussion, for board questions. Mr. Pastor.
So the boat is 6 feet longer than what's allowed, right?
Correct.
And 1 foot taller.
But to clarify, the boat on the trailer, yes, because of the trailer.
And the reduction you're asking for is 5 feet.
Yes, so that's from the property line, which is about 20 feet off of the street into my front yard.
Okay. So I guess my point is that it's the boat is exceeding the code, not the property. The property's not creating this situation because if the boat met the code, you wouldn't need the 5 feet.
That's true. If the boat was smaller, I would not need it.
Which is pertinent because, you know, our criteria is in regards to the property, not to the boat.
Yes, and that's, the addition is what's limiting me. That was already done.
Right, but with a 26-foot boat, which is the allowable maximum anyway, you wouldn't need the 5 feet.
That's a true statement.
So really, the variance you're asking for is really in relation to the size of the boat, not the house or the property, because if the boat complied, you wouldn't need that. So I just want to point that out because our criteria is about the uniqueness of the property or the buildings. And in this case, the property and the buildings aren't causing your issue. It's the length of the boat that's caused and the height of the boat that's causing the issue. And you'd like a reduction in the setback to address the boat,
True.
but not the building.
That's true.
In this case.
Yes. But I think that's why the code allows those few items to be varied, is because if you have a property that can facilitate it where there is not a site obstruction, I can.
Right, but you don't. So you're asking for both. Right? So if you had a 32-foot boat, but it fit behind your setback, then you could come ask for a longer boat.
Well, you
and
wouldn't
you can
need-
ask for both, which you're doing. I'm just saying that you're asking for both. So the size of the boat causes the issue, not the property in this case.
Sure, I agree with that. I just want to be clear. If it was behind the front facade, then there would not be a size restriction. So if I could get it, that's why I can pull the garage down, because as soon as I get that hitch behind the front facade, none of those size restrictions matter anymore.
Yeah.
I have a question for staff. I don't know if it's for, hold on, I don't know if it's for you or for legal. How does the, normally our variances run with the land, how does it work with this boat issue? I mean, a boat, is this a boat that's specific to this house? So if another owner comes in with a different boat, that they need a new application, or if they have the same boat, it's okay? How does that work?
Kamaria Pettis-Mackel from the City Attorney's Office. What the board is approving does run with the land. It runs with the land. So if another property owner were to come in to ask for something different or want an even bigger boat, they'd have to come back here before this board because it'll exceed what the board has already approved. But it's not running with the boat, it's running with the land.
Right, but it's boat specific, right? So if they come in with a boat that's
That's what these setbacks are approving.
right, but what are the chances that the next owner of this property is going to have the same exact size boat?
But I can't answer that, but what you're approving are the setbacks that addresses
Okay.
his concern with his boat.
All right.
So again, the board
Is there
has,
any way you can word it so that it is specific to the?
no, it's not specific.
Normally, it's site-specific, though, right? Normally, we say, we're building it, it's specific to the site plan that's here, and the next person that comes in gets that, and they can rebuild it if it's torn down.
The site plan here is regarding the setback reductions that he's asking for. That's the site plan.
But also the length of the boat and the height.
That is true. Yeah, that's why he's asking for 3 variances to
Yeah.
address those issues.
Yeah. Yeah.
So, and while we're on the 3 variances, I understand there's 3 variances. He has to prove the hardship for each of the 3 variance requests. It's not just one, like a previous application that had 2 grand trees. This is 3 separate variance requests that he has to prove the hardship criteria for.
Yeah, it's kind of like a chicken and egg though here in this situation.
Everybody wants to know what the chicken is.
Or like, how do you prove that you need a longer boat allowance? Right, because it sticks into the setback. Well, why is it an issue? Because the setback's too close, you know? Well, what about the height? We're not even talking about the height, but how do you justify the height? I don't know.
I mean, I can speak to that a little
Yeah,
bit. Yeah, so I think because in that code, it covers crafts and RVs. So in that example, the image that I showed of the RV, for example, that is a significant intrusion on visibility because the RV goes all the way to the front. The front of my trailer is a metal beam. Right? So I think that that's part of the reason.
Yeah, maybe, but, you know, the right-of-way from your property line to the road is the safety zone. So your property line is your property, and you're not gonna cross over that.
Correct,
in any
no.
scenario. So while maybe an RV is more visually restrictive than a boat, they're all behind your property line. So, you know, really the issue's on the property. It's not necessarily vision out into the right-of-way in this instance. Sometimes.
Oh, the property that we moved from was also in Tampa, and that property line went to the street. So this is kind of
Right,
a different
totally
situation where
different.
it's 20 feet back from the street.
So you said that if you don't get the approval, you have to take down part of the building. But I mean,
The addition.
reasonably, this is a movable object, so you don't have to do that. You just have to store it somewhere else, which is an option.
I took that, so before I moved it to the house, I had it in storage, and I have pictures, and I'm actually on the wait list at other places. So I had it in storage, and this was after 3 weeks of being in the high and dry. I suffered damage on both my lower units. That was in 3 weeks. So that's when I pulled it out of, so this is all electronic, electrolysis, yeah. So, and it's on the lower units, it's on all the hardware, even though like the zincs and everything are fine, just from it sitting in the slip overnight, I would come back, leave it, they wouldn't put it away till the morning. In 3 weeks, I had damage like that, so I pulled the boat out, brought it to the house. That's when I got, the code enforcement came by. So I'm on the waiting list at McDill, so I work on McDill, I'm a disabled veteran, I'm allowed to store it there, but I have an email from them actually that states I'm a year to a year and a half away from being able to put it on McDill.
Maria Pettis-Mackel from the City Attorney's Office. That information is not what the board should use in order to determine whether or not the hardship criteria has been met.
Okay, that's all my questions.
I just have one odd question.
Sir.
On the addition, is that where your garage is?
That is the garage.
So you could open that garage door.
I can't get through, I'd have to
You can't even get the engines back in to make it.
Oh, yeah,
You could technically back that thing up into the garage far enough to where you met criteria when the code enforcement guy came out.
No, because the garage isn't wide enough to fit it. It's only one car. I only have a one-car garage.
You can back the rear end of that boat into it.
I can get the props in, but it's not enough. It's not 6 feet.
It still won't make the code and the.
That's what I mean. I can probably save 2 to 3 feet because of the motors, but I
Right.
won't save 6.
And there's no alternative on the front end of that thing with the distance that one beam comes up with the hitch on it? That couldn't be shortened?
It's not it doesn't, I could probably get a different trailer. The other issue I have is I could meet the 5 feet. I don't know if the drawing is still over here, but I could meet the 5 feet if I can't the trailer, right? If I was to not park the trailer straight, but it would look terrible if I have the trailer and the boat parked at this angle so that I am within the 5-foot setback. I could do that if the board only wanted to grant the height and the length. I could meet the setback. but I'd have to park the trailer where it's not,
Right.
it's not gonna look appeasing. I actually have a big U driveway, I could park it, you know, horizontal in front of the house, but that's,
Right.
Any other questions? Seeing none, you have 3 minutes for rebuttal.
I'll waive that.
Okay. Well then, I'll close the public hearing and open it up for motion or board discussion.
Judge Kamaria Pettis-Knuckle from the City Attorney's Office. Mr. Chair, there were letters of support, as the applicant did state, and there are additional letters that the board received.
Okay, do you want to pass this over to us?
I believe you had it in the
I have,
packet.
we definitely have some letters in our packet.
And if you could just acknowledge that, Mr. Chair, that you received those, that the board has received those.
Okay?
those,
Consider it so acknowledged that the board has received letters of support.
And there's the letters of opposition.
There's, right. Let me see, 1 and 1, did they come in separately? Is that what?
Anastasia Barnes, I just want to say, there were several letters of opposition. However, due to the many letters of opposition in general, many received at a later time. So your packet was given 2 weeks ago? So other letters came in, and those were the separate, part of some of the separate emails you received.
Okay.
And so I have those here, but I have those here if anyone wants to look at it, but I just want to note it part of the record that they're received.
Okay, thank you. All right,
You should probably be allowed to rebut if you want to know.
yeah. If you have anything else you want to say.
I can
since-
speak to so the letters of support, I believe that there's 5 total letters of support and 3 letters of opposition. I'll just broadly speak to the letters of opposition. The neighbors that opposed, 2 of them live on the north street of me, so they don't live on my street. And there was confusion on what the setback meant. So if you read their letters, they think the setback is to the street, not to the property line. So that was their primary concern. Their other concern was it wasn't going to set a precedent, which I know every case is handled individually, so that's not true. The other opposition, they live a half a mile from my house, so I'm not sure why they wrote in. They had the same issue, though. They thought it set a precedent. They talked about property value due to the site of a boat, but I don't think appearance is mentioned in the code, and I keep the boat clean, and so.
Okay, thank you, appreciate it. All right, with that, we'll close the public hearing and open it up for motion or board discussion. Motion. Mr. Farrell?
Yes, sir. Okay, move that the variance request for case VRB, 21104, for the property located at 4415 West San Rafael Street, be granted as depicted on the site plan presented at the public hearing for a reduction in front yard setback from 25 feet to 22 point, oh, excuse me, I'm sorry, wrong one. For a reduction of front yard setback from 5 feet to 0 feet, as described in section 27-283.11 A5B1, to park a boat on trailer, and to also to request an increase in the allowable craft size from 10 feet in height to 11th in height, and from 26 feet to 32 feet in length, based upon the applicant presenting competent and substantial evidence in the record of this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in 2780 of the city code. Specifically, that the applicant has shown a preponderance of other cases in the neighborhood which exhibit the same situation, exists the same situation, and I'm sorry, it's not a, but the client is a disabled vet.
That's not a criteria.
Not criteria, sorry. Okay, then I'll just leave it that The client has provided sufficient evidence that there are certainly many other similar situations in the neighborhood, and that certainly as an alternative, he could get the boat. As an opposed alternative, it seems unreasonable that he should park it in such a fashion that it would disrupt the harmony of the neighborhood.
We have a motion by Mr. Farrell. Is there a second? No second?
So that motion fails?
Right. Motion fails due to a lack of second. Does anyone else have a motion that they would like to make?
I'll do it, move that the variance request for case VRB 21-104 for the property located at 4415 West San Rafael Street for a reduction of front yard setback 5 to 0 foot, section 27283.11, A5B1, to park a boat on trailer. Request to increase the allowable craft size from 10 foot in height to 11 in height, and from 26 to 32 feet in length. To be denied due to the failure of the petitioner to meet its burden of proof to provide competent and substantial evidence for the record, and in this public hearing of an as necessary hardship of practical difficulty when considering the 5 hardship criteria as set forth in section 2780 of the city code. Specifically that this is a self-created hardship, really has, it's a boat that you could find alternate. You knew you had this boat, you knew you bought this property. There's really something that you created on this property.
Okay. We have a motion. Is there a second?
Second.
We have a motion by Ms. Johnson, second by Mr. Pastor. All those in favor of the denial, say aye. Aye. All those opposed? Okay. All right. Motion to deny passes 4-3.
Thank you for your time.
Okay, next case.
Is that clear enough?
105. No, you're right.
All right, the next case before you is
Can you just
VRB.
state your name for the record, please?
Okay. Jayton Madhu with Development Coordination. The next case is VRB 21-108.
I think I have a conflict.
Oh,
I think that the agent is one of my lawyers that works on zoning cases with me.
Is Tyler here?
Wait, Tyler's not speaking, I'm speaking.
Okay. Well, he's listed as the agent, so does that make it a conflict?
Kamaria Pettis-Mackel from the City Attorney's Office. Mr. Pastor, that's something, I can't make that decision for you. I can give you the form, but it's whether or not you think you could be fair and impartial. Do you have any personal interests regarding this project?
No,
Are
I
you
don't know
aware of it?
anything. I don't know anything about it.
Okay. Do you think you can be fair and impartial to the applicant regarding this request?
Sure.
Thank you for letting me know. But just for the record, you're going to stay on regarding this case?
Yes.
Okay.
the property owners are Michael and Susan, and they'll be represented by a rep from Tyler Hudson. The property is addressed at 2904 West Angeles Street, and it is on RS50. The variance request is to reduce the side yard setback from 7 feet to 3 feet, and reduce the rear yard setback from 20 feet to 17 feet. And this is in order to construct an addition to an existing single-family residence. That's an aerial showing the subject property and the surrounding zoning. And this is a site plan that was submitted with the application, showing the requested addition highlighted in pink and sectional elevations for the proposed addition. The board would grant a variance subject to section 27-80, and staff is available for any questions. Thank you.
All right, if the applicant would come up, state your name, your address, and confirm that you've been sworn, please, and then you'll have 10 minutes.
I'm Alex Shaler, 400 North Ashley Drive, Suite 1100, and I have been sworn in. So I'm with Gardner Brewer Martinez Montfort. As I mentioned, our firm is representing the applicant, Susan and Michael Prideaux, on this case to add in addition to their existing single-family home. 2904 West Angela Street is the address. It's located east of McDill Avenue in Palmacia Country Club, and it's surrounded, as you can see, by other single-family residential developments in the area. The variance request, as mentioned, is to reduce the side yard setback from 7 feet to 3 feet and reduce the rear yard setback from 20 feet to 17 feet. And this is to build the 319 square foot addition to the rear end of their house. For hardship justification, we have submitted an extensive memo that should be in the packet. It was uploaded to Acela, but I can definitely go through that as well and speak it into the record. But just to kind of give a brief summary, their existing home was built all the way back in 1925, and their original floor plan has been maintained despite the fact that they are running out of living space. The property includes large sprawling trees that prevent an upward extension to the structure because they looked into going to potentially another floor. But the minor addition will allow the historical integrity of the home as it stands to be maintained and will prevent them from having to knock it down and build something bigger that accommodates the size of their family. I've noted a couple different supporting policies from the land use, relate new buildings and development to the context of the neighborhood and community, promote physical environments of the highest quality, which emphasize the special identity of each of the city's neighborhood. This area in Palmacia obviously has a lot of history to it, so they want to keep the house as it is and just add on to the back of it. The staff report findings, I have a slide on that too. Natural resources was consistent, right-of-way consistent, transportation or review was not required for this case. This slide I wanted to point out, just showing that the fact that they had mentioned when they came to us that there were a lot of their neighbors who had received similar variances, given the size of their homes and the size of their lots in the neighborhood. So outlined in blue, you can see are different variances for various side and rear yard setbacks that were granted in their neighborhood. The yellow star is where my client's home is located. And like I said, those blue boxes around the different areas are other varying addresses that have received variances in the past. And I've summarized those in a table so you can see them numerically, kind of what they have requested in the past, so and what's been granted. 2910, a rear yard setback from 20 feet was approved for 13 feet. 2801, a 20-foot rear setback was reduced to 2 feet. Side yard 7 feet to 3 feet, which is exactly what we are requesting. Again, you can see as you go down the list different requests, but I wanted to note that our rear setback is less than what has been approved in the past for the surrounding area, and the side is about on par with what's been approved in the past. And like I said, I can go into detail about different hardship criteria and answer every individual question if needed. And I can do that in the rebuttal if needed, but if not, that's the end of my presentation. I open it up for questions.
All right, thank you. If that is the end of your presentation, then we will look to the audience to see if there are anyone in the public who would like to comment on this application. Is there anyone in the public? Seeing none, then I will open it up for board questions. Does the board have any questions?
Did you talk to any of the neighbors?
They have not received any kind of opposition from the neighbors. We public notice to everybody, so as far as I'm concerned, I think everybody was fine with it. So we didn't receive anything directly from anybody else.
Again, Kamaria Pettis-Mackel from the City Attorney's Office, whether or not neighbors support or oppose the applicant still has to meet the hardship criteria.
You have a question?
So I know there's a precedence with setbacks of 3 feet, which I think are very narrow, and I'm sorry they are precedents. Is there any way that this addition could be reconfigured within the required setbacks?
So what I can put up the site plan. Let's see. You guys can, like, the numbers are kind of hard to see, but it's actually 3.125 feet to be exact, but we had rounded everything off. But as you can see, the most part of the side yard will remain as the existing side yard setback. It's just that one area where this, if you can see this, just the one area where this expansion is, that it's going to shrink right on this side here, if that makes sense. But this is still going to remain as is, so the majority of the home will be relatively buffered from the neighbor.
Yeah, I guess when I look at this, 5 to 6 feet is a standard width a person would walk through, and for safety reasons, like there's side setbacks for a reason, not just for partial areas, for access and drainage and lots of other reasons. So just seems narrow to me. So.
I think, are you finished? Just sort of to piggyback on hers, is there a reason that you can't just slide it right behind the house? I think that's more of a...
Yeah, no, there's a tree right there. If you can kind of see it on the survey there. So they were trying to do everything they could to save those trees. So that's why we had proposed it where it is now. But there, if you can kind of see there's a 10-inch tree there
You can zoom it
in the survey.
Can you zoom it in?
Yeah.
I think you also run into a problem if you slide it to the east to line up behind the house. There's minimum setback requirements between roof to roof edges that you might start to impede upon on that frame garage if you slide it too much closer.
Understood.
Any other questions? Seeing none, you have 3 minutes for rebuttal.
Awesome. Like I said, this client of ours, they've lived in this neighborhood for forever. They love it. They love where they live. They love the neighbors. They want to stay here for as long as they can. But like I said, given the fact that they're running out of space, they need to add this addition in the terms to just address that overall hardship. And going off of what you guys were talking about in terms of moving things and side setbacks, they put a lot of thought into this plan, and we've been running with this in terms of, like I said, trying to avoid everything we can. The trees was the biggest issue with this. They were so insistent on keeping the trees, and I mean, we completely understood that and wanted to accommodate that as much as we could, understanding that that wasn't as necessary of a variance if we could avoid it. So trying to avoid those trees, and like I said, I mean, they haven't received any kind of opposition from the neighbors. This is a friendly request, and like I said, just something that they could use to accommodate. So thank you.
All right, thank you. That concludes your presentation. I will open it up for board motion or discussion. Anyone have a motion?
I'll make a motion.
Ms. Decker, fire away.
I move that the variance request for case VRB 21-108 for property located at 2904 West Angeles Street be granted as depicted on the site plan presented at the public hearing for a reduction of the west side yard setback from 7 feet to 3 feet and a reduction of the rear yard setback from 20 feet to 17 feet with an encroachment for eaves and gutters based upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 27-80 of the city code, specifically that the hardship or practical difficulty does not result in the actions of the applicant as the applicant purchased the property in its current configuration, and the property was constructed nearly 100 years ago and just doesn't comply with the sort of storage and functionality requirements of a modern household. And the variance, if granted, will not substantially interfere with or injure the health, safety, and welfare of others who would be affected by the overall allowance of the variance, as the variance setbacks are in line with similarly situated houses in the neighborhood.
Okay, we have a motion by Ms. Decker. Do we have a second?
Second.
All right, motion and a second. All those in favor say aye.
Aye.
Aye. All those opposed? Okay, motion passes 6-1. Have a good evening.
Thank you.
Last case?
Jane Madu with Development Coordination. The next application before you is VRB 2124. And the property owners are Eric and Maylene Racine. And they will be represented by their agent, Raphael Rashkin. This property is addressed at 708 South Lewis Avenue, and it is zoned residential single family. The variance request is to reduce the rear yard setback from 20 feet to 5 feet in order to, and this is for an existing covered patio with a rear yard for a pool. That is an aerial of the subject property with the surrounding zoning districts. And this is a site plan. I'm sorry, I think it's upside down. This is a site plan of the of the property with the yellow highlighted area showing the area and the scope of work. We have no pictures at this moment. The board would grant the variance with subject to section 27-80. And the staff is available for any questions. Thank you.
Do we prefer mask, no mask?
You can proceed.
I can proceed? Okay. My name is Raphael Rashkin. I reside at 12221 Lexington Park Drive. That's Tampa, Florida, 33626.
And you've been sworn.
And I have been sworn in. As you've heard, our application involves a variance regarding a screen enclosure. I think it's a little difficult to understand simply from the application, what's written itself. So I think this will help kind of describe what we have going on here. The reason why the current structure is not meeting the setback requirement, normally a screened-in enclosure only needs to meet a 5-foot setback. So I'm going to try to show you some pictures here. I don't know if you have these. I'll remove this. Is this right side up for you guys? So that's kind of a side view of the yard there. You can see that it meets a normal setback for the screen enclosure. However, we don't have just the basic screen. A small section of the screened-in area has this, what we call a composite roof material. It's basically like a dense styrofoam or something like that. It's not, when you first look at this, you might think, oh, it's a big sheet of metal, but it's actually, it's a foam. This actually is a thin piece of aluminum, very thin on the very bottom. That's giving it the reflection. But it's essentially thick styrofoam. It blocks the sun. It keeps pollen from coming down through the screen. You may have seen these before. It also allows for the light fixture to be put in there. What happened here is the screened-in area, when it was submitted for the permit, didn't have this composite roof material on the plan, and when it was constructed, we went back and tried to revise the plan to bring for the permit, revise the permit to bring it into compliance with what we actually ended up with. And that's when we were notified that, because there's this foam instead of the screen, that it would be required to have a 20-foot setback. So that's how we got where we are today. It is currently there. I guess we've been told it's a violation. We are here to apply for a variance to have it changed to a 5-foot setback as the normal screen would be. Again, we're not talking about a structural, this isn't like someone built a patio. Just another view for you. Kind of see what's going on here. It's really a thick piece of styrofoam coming off the side of the building. It is a corner lot. The house itself is pushed back pretty far up the property in order to meet the front setback requirements, which is the reason why there's very, very little space in the backyard. When the house was built, you can see here, it's pretty narrow. You can see the house here and then the back here. It's hard to construct anything back there, but they did a pretty good job squeezing it in and meeting that 5-foot setback. The problem here, again, is the piece of composite. The composite roof is very important. The Raisins, Mr. Raisin's here with me today. The whole family has terrible allergies. We actually have a doctor's note here. I understand this doesn't necessarily have to do with the property itself, but just to give you an idea about what we're talking about. They essentially can't really be sitting back there in Florida with all the pollen and all that back there. So that's the reason they wanted to have this composite roof material there, in order to kind of block that out so there's a safe zone where they can actually sit there as a family and enjoy the property. Again, if the house hadn't been pushed back so far in the lot, there might have been more space to make it work if we had known it was an issue to begin with. But that's not what we have here. Again, a corner lot, and the house, in order to meet the front setbacks, has to be pushed all the way into the back. But point out too that having, as with all screen enclosures, in the case of high winds, a tropical storm or hurricane, we would expect that the enclosure will help to trap any debris, flying furniture, anything that would fly up in the air. That roof material is, sturdier than the screen. It's certainly not, wood or metal, but it would do a good job stopping any kind of patio furniture or planters going flying through the air, making it safer for the community and the immediate neighbors who have provided letters of support. These are the abutting neighbors. And it simply reads, I live on and own the property that abuts the property on which the Raisin residence is located. I am in favor of and would not contest a variance allowing the Raisins to keep their screened-in back porch as it appears now, including the section of composite roof and the other materials used on the back porch. Of note, to our knowledge, nobody opposes this. All the proper notices were done, and make sure I'm not missing anything before I turn it back over to the board. Yeah, also worth noting is just that if you look at, again, this back patio area, this section here, we're looking at this is actually a glass door to the right. You can't see it right there, but that's all glass. The roof also protects, in the case of a storm, any kind of falling debris from coming through and injuring anybody or destroying the home. See that there. And I'll turn it over to the board.
Okay, does that conclude your presentation?
Yes, it does.
All right. Are there any members of the public who would like to speak on this presentation, on this application? Seeing none, I'll open it up for board questions. Any questions from the board? Yes?
Would you be willing to accept a condition that this additional roofed area never be enclosed, meaning walls?
Oh, yeah, of course, yes, yes, of course.
I have a question.
Yes.
I assume the pool and the screen, were they built at the same time by the same kind of contractor? Is that, or were they
Yeah,
two
yes.
separate?
The pool, yes, the pool was built by the contractor, and then the screen didn't work, was subcontracted, actually. And Mr. Kevin Fry was the subcontractor. He's here today. I think he was actually here a few months ago as well.
And so he thought, I mean, I find it strange that these projects are being built by these kind of screen enclosures. This isn't the first. It seems to be a trend that they're built and then they come back to the board for a variance. And I guess the client wasn't told that this wasn't permissible?
No, that's not at all what happened. Actually, embarrassingly, what happened was there was a miscommunication before. So I'm the attorney for the pool company, so this was originally brought to my attention because they basically made a mistake. So the plans that they discussed with the homeowners were supposed to include this composite roof. What happened was when my guys sent the wrong plan is what happened to the subcontractor. So what does the subcontractor do? The subcontractor goes to get the permit and he uses the wrong plan. And we realized it because Mr. Raisin said, wait a minute, they didn't just build this. They were building a screen. And Mr. Raisin said, no, that's not what I wanted. I wanted this other thing. The second comedy of errors here was that the subcontractor didn't realize that there was going to be an issue with the setback. So, he innocently asked, when he went to revise the permit, he thought, okay, well, I'll just revise the permit, no problem. That happens all the time in construction. And that's when they were advised, no, this is very different because there's that foam. Now, I'm not a structural engineer, but we're not, again, my point was before that we're not talking about an extension. This isn't like it's not load bearing. It's just a thick piece of, a foam blocking the pollen from coming down and keeping a shade area that, his family can relax in.
But were it not for that one panel, everything else is code compliant it's been engineered, it's been permitted, all of that. It's just that one composite panel, because of the definition of its structure, that now that it attaches to the main house, that's why construction service is now telling you that now you fall under primary setback requirements, not separate screen.
That is correct. That is an accurate description of the situation, yes.
Is there a building permit for the pool enclosure? Are you stating that?
If I could, my subcontractor has been sworn in, and he actually has a little more information about boots on the ground, getting the permit and all that.
I just want to...
Could I defer?
I just want to...
I don't want to misrepresent anything. My understanding is that a permit was...
That's it. Were it not for that panel, it's a regular screen enclosure, and it meets all the standard, sits in with the setbacks and everything else. The only thing in question is that one panel, and you folks are willing, if there's a condition on this approval, that panel, that area would never be enclosed in order to make a conditioned space, which would in fact trigger a primary setback violation.
Absolutely. 110%.
And again, Kamaria Pettis-Mackel for the record, I just wanted to verify so that this record is accurate that there is a building permit pending or active or issued regarding this pool enclosure. I just want to make sure that the record is accurate. So if someone can verify that.
And the building inspector caught it, right?
Kevin, I'm sorry. That's my understanding. I just want to make sure the record's clear. So Kevin was actually the subcontractor, Kevin Fry. If you can come up here and give him your name and address and let him know you're sworn in, and maybe you can answer the questions and help us out here.
Good evening. Kevin Fry, 16325 East Course Drive, Tampa, Florida. Okay, and
have you been sworn?
I have been sworn in, yes. To answer your question, there is a building permit for the job.
Thanks.
That's pending this decision?
Yeah, is it pending or is it active or what's the status?
I believe it is it's active and then pending this decision.
Got a red tag.
I don't think it's been inspected or anything.
Okay.
But But the original plans with the screen, without the solid roof, was that already approved?
That was approved, yes.
Okay.
Yes. And we applied for the revision, and then it was denied
Right.
because of the setback.
Fair enough. Are there any other questions? No? Okay. You have 3 minutes for rebuttal. If you need it.
I don't need it. I'm all done.
All right. Thank you. Then I'll open it up for a motion from the board. Mr. Pastor.
I move that variance request for case VRB 2124 located at 708 South Lois Avenue is depicted on the site plan and presented at the public hearing for a reduction in the rear yard from 20 feet to 5 feet with encroachment of eaves and gutters with the following condition: that the space underneath the roof never be enclosed, that said variance as condition be granted based upon the applicant presenting competent substantial evidence in the record of this public hearing of a necessary hardship or practical difficulty in considering the 5 hardship criteria set forth in section 2780 of the city code, specifically that the roof doesn't exceed the limits of a screen, and this is actually a screen porch roof and not a typically built primary structure type of roof, and that it is only enclosing the screened area that was previously approved.
All right. We have a motion. Is there a second?
Second.
Motion by Mr. Pastor, second by Mr. Farrell. All those in favor say aye.
Aye.
Aye. All those opposed? Okay. Motion passes 6-1. Have a good evening.
Thank you.
We're done. Have a good night. Exactly. Exactly.
With the owners of the property since the very beginning. You can look at this. Let's see in this photo, there are a few reasons why we made this decision. The property line encroachment was obviously the biggest driving factor. However, this side of this overhang with the direct corbel design we made all of rust on cypress. If you walk up on the edge of the bottom corner of this roof, it would have collapsed. You physically couldn't walk out on it. It was dropping. It's because of the shrubbery, like you've seen in other photos, you can get a real street from the floor, so that's only half, but you can see that actually the roof line, or ridge line is going across that where it's dropped significantly. At 4 feet, it was almost 6 inches at the very, very peak. And when we got that back, the portables back, that came right up around the height, it was way below the weight of the offer there. And also, if you look at these corbels, the brackets, the jack on the bottom on the angle, it's not a 45-degree angle, it's actually a very low angle. It goes out. In conventional framing, it won't support nowhere near as much as those shorter corbels. It's on a steeper angle. Conventional framing, the steeper you can make it, the stronger it can be. So it was different all those, so when this roof is finished, it will last longer before it has to be torn apart. Now, all of the fascia, the new fascia, is roughed on 2x12 cypress. The existing corbels are 4x4 roughed on cypress. Unfortunately, roughed on cypress is great, it lasts almost forever. However, it's not as dense as, say, southern yellow pine or an old hard pine, which is what we need on this. These are becoming structural elements, they're not just decorative. This is the only thing we're holding this thing up whatsoever. And you've seen many of the photos of those elevations where hardwood, and it had a stone roof, 1x4 board overhang, soffit, which is actually the decking on the roof. There was on the bottom corners, especially in the rear, unfortunately. They were bought out back there, but part of the best part of what we cut off, got rid of that. So it was advantageous for the owner also to not have to shake somewhere that bit longer. The final thing I'd like to point out is where the property line portion does occur on the this elevation here. Statistically, tried to do this. I had a helicopter or something, some sort of possible. We did actually rent a lift from the street. I reached 8 feet to be able to reach out and try to get this done, but you can't put 2 or 3 of them in there. And that's supposed to be needed to try to rebuild that all the way up to the full 4 feet or any type of dual bar drafter without being on the neighbor's property or disturbing his property whatsoever. You just physically can't do it. There's nothing there to walk on, nothing to support it at all. So that's all I can say. We're directly back there.
My name is Kenneth Bolden. I'm speaking on behalf of the owner of the property. My family has been in the neighborhood for many, many years. My grandparents purchased 5758 Swan in 1924 and lived there for in excess of 60 years. And my sister